Searching for music for your next video? Then you need to check out our list. With amazing new music added daily.
two parts. So the first part is an automated analysis. So I will take the samples and put them into the microscope, and I will set up parameters on the computer telling it, here are the samples I have, here's where they are located on my sample holder. From there, the computer will scan the surface of those samples, looking for potential gunshot residue related particles. If it comes across something that it thinks could be gunshot residue, it will stop and take a picture of that particle and also save the coordinates for where it is located on that sample. So it will finish going through and scanning all of the samples, and after that, I will do the second part of our analysis, which is the manual analysis. So I will go back to those particles that the instrument flagged, and I will examine them. So I will look at their shape, and I'll see if that's consistent with gunshot residue, which would be something that is smooth or round in shape as the result of a high heat reaction. In addition to that, I will look at the chemical composition of those particles and make the determination for what type of particle it is that I am looking at.
And the automated process is performed by the SEM, right? The SEM for short.
Yes.
And what is it looking for? Those particles that we discussed earlier, or the compounds, the barium?
Yes. So basically, the way the SEM works is kind of based on brightness. So the more dense something is, the brighter it will appear. Because lead, barium, and antimony are heavy metals, gunshot residue related particles will appear very bright. So it's scanning the samples based on brightness. And if it finds something above a certain brightness, that's when it will stop and collect a spectrum to determine what elements are in there. If there's lead, barium, or antimony, or any combination of those, that's when it will save where it's located and take a picture of that particle.
And would a demonstrative aid assist you in your testimony to the jury as far as what the SEM shows?
Yes.
Again, ladies and gentlemen, the witness is going to be using a visual or demonstrative aid to assist in explaining or illustrating her testimony. Just remember that the testimony of the witness is the evidence. However, this demonstrative aid is not to be considered by you as evidence in the case unless it's later received in evidence, and you should not use it as a substitute for evidence. Only items that are actually in evidence will go back with you to the jury room during your deliberations. You may proceed, counsel.
Thank you. And without getting into the actual results, we're just going to orient the jury to the chart that I have here, beginning with the top left.
Yes, so the top left is an image kind of showing where the particle is located on the sample, and that is taken at 400 times magnification.
And the top right?
That is now a closer up image of that particle taken at 3200 times magnification, where you can see clearly that it is bright, it is round in shape, and you kind of are able to visualize really the morphology of that particle.
And bottom left?
So that is what is called the EDS spectrum. Basically, it's just showing you what elements are present in that particle. So PB is lead, BA is barium, and SB is antimony. So you see peaks for all of those present in that particle. Therefore, it is a particle that contains lead, barium, and antimony, which makes it characteristic of gunshot residue.
And are the peaks that we see consistent with the amount of that compound within the sample?
Yes, overall, the height of the peaks relate to how much of that element is in the particle.
And finally, the bottom right.
So that is the image that the instrument takes during the automated analysis.
And did you receive a sample in this particular case for analysis?
Yes, I did.
Your Honor, approaching defense counsel has been previously marked the state's LLL for identification purposes. Your Honor, permission to approach the witness?
You may.
And if you said you handle anything biological, there are gloves right there, and the top has been open for ease of access. Tell me if you recognize it first and if you need to open it. If you can just keep it outside the view of the jury.
I do recognize it.
And how is it that you recognize it?
This is one of the items that I received in this particular case.
And it was one sample, and what did that sample contain?
It contained a collection stub labeled as coming from the inside of a Jeep.
Okay, and is that in the same or substantially the same condition as the last time you saw it?
Yes.
Your Honor, at this time, the state would use into evidence because pre-marked states LLL as the next numbered exhibit.
No objection.
Thank you, it'll be admitted. What's the next number?
60.
60 in evidence, thank you.
Looking for 57. One moment. I'm showing you what's been entered into evidence. Evidence states 57. Do you recognize that?
I do, yes.
And what is that?
This is a gunshot residue kit that we received in this case.
Okay. And did you analyze states 57?
Yes, I did.
And did you ultimately analyze state 60?
Yes, I did.
Okay. So, let me see. Grab your scissors. Go ahead and open states 57. And I'm going to ask permission from the judge for you to step down.
Okay.
You may.
If you want to open it, grab some gloves, and we'll
Okay.
go to the machine.
When there's nothing holding you back, what would your thing be?
Just if you can publish states 57. And the contents. So you received one sample, but there are two tubes. Yes. What are they representative of? These were samples that we had received that are labeled as coming from the right hand and the left hand.
And who's the individual?
Cortland Henry.
And you can put those back in. And if you can publish states 60. And we have one tube, and what is that representative of?
It is labeled as coming from inside of a Jeep.
If you leave it, it will adjust. Thank you. You can put it back in and take your seat. Okay, we're going to start with case 57.
Did you ultimately have a chance to analyze and go through this SEM process, which was the automated process, and your individual process, in order to come up with an opinion as to the presence of GSR?
Yes.
And what was that opinion? And if you can specify both the left and then the right.
So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and two component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 2-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay. And what affects the presence or absence of GSR on a person's hand or any object?
Sure. So if there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
Okay. And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results of Cortland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or 3 compounds that you were looking for, and which compounds were present in Cortland Henry's left hand?
Lead, barium, and antimony were present in that particle.
So all 3 components.
Yes.
Bold. It begins in your soul. It moves you, empowers you. It comes from shared knowledge, from community. Bold is born at Bowie State University. It's how we prepare students to break barriers and change the world. It's an affordable, world-class education focused on nurturing those ready to take charge. So bring your bold. Visit Bowie State University today, on campus or online. Bowie State University, taking tomorrow boldly.
Okay, and let's move on to state 60, which was the sample from the Jeep. What were your results? And again, did you also go through the SEM automated process and then your individual characteristic process?
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 2-component particles.
Okay, and what does that mean?
So, like I mentioned, 2-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with 2-component particles, or any of the particles we look at, if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of 2-component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis, and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
Okay. And I want to ask you about presumptive tests. Are you familiar with them in general?
I am, yes.
Are you familiar with the friend or foe presumptive GSR kit?
I am.
What is that kit testing?
That kit is like you said, a presumptive test that is looking for the presence of nitrates, so nitrogen containing compounds.
Okay. So for instance, these GSR kits are made to essentially alert to the presence of a certain compound.
Yes.
And the friend or foe kit specifically alerts to the compound of nitrogen particles.
Yes.
So the presence or absence of nitrogen particles.
Correct.
And are presumptive tests relied on exclusively?
No, they are just a screening tool. Like I mentioned, they're looking for nitrates, and there are many things that can contain nitrates. So they are not conclusive to the presence of gunshot residue or gunpowder. They are really just to be used as a screening tool.
Your Honor, moment to confer.
Yes.
Nothing further.
Councilor Zane Cross,
Yes,
you ready to proceed?
thank you. Good morning.
Good morning.
I don't think we've had an opportunity to meet.
No.
You got the sample from Miramar Police Department,
Yes.
specifically Detective Moretti directed it to you.
Yes.
And when we talk about GSR, or gunshot residue, you're aware that GSR can be found on clothes, right?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection, calls for speculation outside the scope of the court.
Well, I don't know that it calls for speculation. If she knows she can answer the question, overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
But if in your examination, had you received clothes, you could test those clothes for GSR, correct?
Yes, we can
And you-
certainly test clothing.
And you've done that many times, correct?
Yes, absolutely.
Also, if someone is in a hospital, in a bed in a hospital, do you know if that person has washed their hands?
I don't.
Okay. And by washing your hands, you can get rid of GSR, correct?
Yes, hand washing can remove most, if not all, of the particles on someone's hands.
Do you know if Cortland Henry washed his hands or changed his clothes?
I don't know that.
Could I have one moment?
Yes, sir.
Thank you very much.
Thank you.
Any redirect?
Yes, Your Honor. Is hand washing the only thing, contrary to popular belief, that removes gunshot residue?
No, gunshot residue is easily removed in general. So with respect to the hands, any type of activity, touching or use of the hands can remove particles pretty easily. With clothing, any activity. So if the garment is touching things, if it's laundered.
If it's removed?
Yes, any activity can cause particles to be disrupted or removed.
And you're an independent lab, correct?
Yes, we are.
You're not associated with Miramar Police Department.
Correct, we are not.
You're not associated with the Broward Sheriff's Office.
We are not.
So you can only test what you're submitted, correct?
Correct.
Nothing further.
One question, if
Yes.
I may. You were hired by the Miramar Police Department to perform this test then, correct?
Yes, they're the ones that submitted the samples.
Thank you.
Anything else?
No, Your Honor, nothing further.
Is this witness excused?
Yes, Your Honor.
Thank you very much, ma'am. Can you step down, you're excused? Thank you. Can I see you sidewalk, please? Ladies and gentlemen, I need a few minutes with the lawyers. Please do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in the presence and search and no research. Thank you. Just leave your notepads on the chair. Let the record reflect the juror stepped down, counsel remained, along with the defendant and the assistant state attorneys. So I have, and this has been marked as states JJJ, triple J, and it's a Snapchat account. And so what does this purport to be?
That is the business record production from Snap Incorporated, which is the business that runs the social media app of Snapchat. The records are the records of Mr. Defendant Jamel Demons. They are conversations and statements that he makes, some of which reference this homicide and Portland Henry. And there's in specific comments from Mr. Demons to an individual that's identified by a Snapchat name and it's on there, DHAT is what it starts with, in which he says that Portland Henry did something very important for him. I'm paraphrasing from the language on that. In terms of establishing that those records belong to the defendant, the state has to prove that beyond a reasonable doubt to the jurors. So that is why it's necessary to show that all of the photos and videos in that particular item are of Jamel Demons. In addition, the person that he is speaking to, the one that starts with DHAT, that individual, there are images of her that are transferred back and forth. So that is identified as Mariah Hamilton. That is the defendant's girlfriend at the time. She's also in some of the videos. And then there are videos that the defendant sends to her that in which he indicates you shouldn't be speaking on me, basically discouraging her from speaking with law enforcement.
So regarding these videos, how long are they? How many? I mean, you sent me
Yes, that's
3 pages listed. I don't know how long these take to take a look at.
They are less than 30 seconds each, approximately.
So let's
Sure.
put them in.
The drive that is right there.
Well, yeah, that's fine now. Just has to go back. But I want you to sit over there. Is it all right if you sit over there? Or you... They're good?
I think that might be good.
You can reposition yourself.
Yeah.
Thank you. And feel free to do that throughout.
Thank you.
If there's something showing up on the screen and you think you want a better view of it, you're always welcome.
And this is the business records certification as included on the file from Snapchat.
Yeah, I saw those. I'm not talking about that.
You aren't just one you. There are many sides to you. And all of them deserve the best. Introducing Max, the one to watch.
I'm talking about the actual videos.
So do you want to see the images larger as well, Your Honor?
Yeah, I'd like to know what you're going to show to the jury.
Of
They're
course.
objecting to it, saying it's not relevant. I don't believe there's an objection that's not authentic, that it's, not his account from Snapchat. I understand that. If that's the case, but my understanding is they're saying it's not relevant.
This is the one that I indicated would potentially have the items that defense didn't want in, such as the names of the songs of the defendant.
We don't have to concern ourselves about that. The state agreed to get that out. So
Image of the defendant, an image of the defendant and Mariah Hamilton, image of the defendant.
Now, you're saying that this is the defendant and Mariah Hamilton, and I haven't heard anybody identify her yet. Is that,
Correct, that's why the next witness would do that.
Oh, okay, so the witness is going to do that.
Yes, Your Honor.
she is again. That is Ms. Hamilton. This is the Snapchat logo of the defendant. Moving on to the videos. This video here is before the homicide. It includes the defendant and one of the victims, Christopher Thomas. There is volume to it. I don't know if the TV is turned down.
Gary, can you check on that?
That's good.
It's up. That's 63 or 62. There is a volume.
Try VLC.
That was VLC, so.
Oh.
Yeah, I think that one. Sharon, I'll switch over to a different computer.
The gods have spoken. You need a new, clean, heavenly body wash with Native.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Your Honor, for the interest of time, should the state be proffering the relevance of each video as we go?
No, thank you. I'd just like to see it and see what.
Right.
My understanding. Well, go ahead.
Okay.
Right. All right, thanks for shit. They need the most important shit here. The most important shit here. Like, get right there, like, you know you come back. You be someone pick up on me. Hey man, I'm 19, I done seen 750,000 each. I ordered it, it'll be a meal. Gotta make sure, it'll be a meal, I make sure. You put sad when you get out, dude. Put sad when you get off y'all ass, man. Yeah, get off y'all ass, man. Hey, bro, don't be speaking on him, bro. He didn't do that. He didn't do that. I've been out here about your ass saying you did.
Those all the videos, Counsel?
Yes, Your Honor.
All right, so, Counsel, why don't you tell me your complete objection so I fully understand what you're objecting to on the videos as well as the remaining portion of this Snapchat under, I think it's triple A.
Your Honor, our first objection would be relevance. I think Florida statute 9401 defines relevance as evidence tending to prove or disprove a material fact. There was not a single video that you witnessed there that implicates in any way any fact and issue in this case. I want the court to be aware of what a Snapchat account is versus a video off of a phone. They're two different things. You can access that Snapchat account from your computer that's right before you. So a Snapchat account or any social media account is not particular to a device. This is contents from an account that exists in the cloud or on the platform of Snapchat. and is not peculiar to a particular device. So it doesn't identify a device. It identifies a social media account. The notion that anything a defendant says can and will be used against him is an issue of hearsay. It's not a relevancy issue. None of those videos I haven't heard, and I think that probably we're putting cart before the horse by making me object to the relevance before she advances her theory of relevance. But the fact is, unless I'm missing something, there is nothing there that concerns the events of October the 26th, 2018 in any way. As far as the messages are concerned, it's similar.
Now we're talking about what's in writing, correct?
What's in writing is essentially a dump from that account, a selective dump, I think from August the 3rd through some date in November. If the state is indicating that there are messages there that relate to the offense, then the state should isolate those messages and make its argument as to what the relevance of those statements is, are. But to suggest that you can just dump all statements that somebody makes since birth until the time of their trial, and because it's non-hearsay because it's a statement of the defendant. And by the way, these are exchanges, so a relevancy objection, or sorry, a hearsay objection relates to the statements of the defendant, not the ones that are made back to him in any kind of conversational exchange. Those statements themselves are hearsay because they aren't statements of the defendant. And I'm making this argument assuming, because I'm dealing with relevancy, assuming that those statements are indeed statements of the defendant, which I'm not conceding. They have to have some relevance to this trial and facts in issue at this trial. There are some statements that I observed that seem to be some maybe terse or conversations between him and any person that might cast him in a poor light because of the manner in which he communicates. How is that relevant to this case? So relevance is number one. A statement has to be relevant. So each statement the state would have to establish the relevance of each statement in isolation prior to it being admitted into evidence, saying these are all from his phone and therefore they're all his statements and this is a business record exception and therefore they get in, doesn't cut it. As far as authenticity is concerned, and that's our relevance objection. Relevance must be established. I'll cite the court authenticity issues or authentication issues concern Florida Statute 9.901. And I'll cite the court to some case law that doesn't necessarily deal with social media, it deals with text messages and emails. Simonet. I can't remember if it's Simonet v. State or State versus Simonet, but it's 100 Southern 3rd 180, which stands for concerns text on a cell phone. And it indicates, these are some notes that I took down because I didn't realize she was going to be trying to bring this in today. We had asked for some indication as to the witnesses, and I think this is the only day we didn't get any indication And so there's an element of ambush, but nonetheless, in the Simonet case, it stands for some legal principles that were articulated in that holding that I took note of. One, in that case, there was concern regarding the admission of screenshots of text messages, communications. And the court said it was okay because there was a witness that testified that she was sitting next to the defendant in a car when the texts were made. And the detective recovered a cell phone from the defendant, and the witness identified the text messages between her and the defendant. In other words, there was a party to the communication who was able to authenticate the communication and who the participants are. Another case is Roy, which is 279 Southern 3rd 238.
279 what?
Southern 3rd 238, which concerns emails and texts. And these were emails that were admitted through the investigator that was posing as a 14-year-old in what appears to be a case that concerns some sort of a pedophile sting. And the investigator involved in the exchange, the investigator was involved in the exchange in the emails of the text. One of the quotes that I took from that case says, most common way to identify social media, which would be this, and things akin to social media, is to let the author testify that they're the ones who generated or created it. So there's somebody that is involved in the exchange of the communication that can attest to the fact that they created it or were involved in it and identify the parties that were involved in the exchange. When a participant is used to authenticate electronic exchange, the focus is on the witness's ability to identify the person against whom the communication is offered. In criminal cases, the person communicating with the target of the investigation must be able to identify the target through some personal knowledge or experience. So this establishes that there has to be somebody who participated in the communication, who authenticates the participants in the exchange, and must be able to identify the participants in the exchange. In the Roy case, the sergeant, who was posing as a 14-year-old, acknowledged that he had no idea who was on the other side of the emails and texts. Here we have nobody at all, let alone somebody whose knowledge is insufficient.
This is just a PC affirm case. These opinions are, right? Am I reading this right? This is a PC affirm. That's in the concurring opinions or?
The Roy versus case. I can print it out if you
I'm reading it right now.
I'm not sure what the court is.
It's a PCA affirm.
Meaning the language that I'm reading doesn't exist?
It exists, I'm sure it's there. I didn't read the whole concurrence. It's
Okay,
there, but it's a PCA affirm.
Well, maybe I cited it incorrectly.
No, you cited it right. 279 Southern 3rd 238. All right, go ahead.
Okay, this is language I took from the cases themselves.
I don't doubt it.
Okay.
Seems like it's all here.
Okay. I'm not sure the significance of a PCA affirm meaning.
That's not the opinion of the court. It's the opinion of one judge. That's what his concurrence was. His or her opinion, and there's another judge has a different concurring opinion. There's no specific majority opinion. I don't see one. The other concurring opinion says he'd reverse, but it's a PCA affirm.
I'm not quite sure of the significance of that, but I'm sure the court has a message it's communicating. No evidence that the texts were recovered from a phone, A, belonging to, in the possession of, the appellant pursuant to a search warrant, is another quote. Further, in that case, the sergeant could not identify appellant as a person on the side of the emails or on the other side of the emails or texts. Lamb versus State, 246 Southern 2nd 400, a 4th DCA case in 2018. A quote that I took from that says, a case involving authentication of a Facebook video, or videos here, is also instructive. In that case, the 4th District recognized a distinction between authentication of a video recording and an audio recording. An audio recording would be more akin to a communication that you can't tell the identity of the communicators visually. The 4th District acknowledged its prior holding that authentication of an audio recording, quote, should be made by the technician who operated the recording device or a person with knowledge of the conversation that was recorded. Quoting Santana versus State 191, Southern 3rd, 946, which is another 4th District case. So as far as authentication is concerned, Your Honor, and the PCA affirmed component, notwithstanding, the articulation that is being made repeatedly by district courts of Florida, of this state, and by the 4th District, are that when you are introducing text messages, communications that are in print, audio, somebody has to identify the participants. You can't just put them in and say, this is the guy who said it. You have to lay a predicate of authentication, which the state is not attempting to do. So as far as relevance is concerned, they have to establish relevance of each statement. They can't just say, here are all the communications he ever made, and notwithstanding who he's making them with, whose statements are themselves hearsay, because his statements are statements of the defendant and therefore not hearsay, non-hearsay by definition, they come in. They have to establish the relevance. So we object. One second. So the communications are not particular to a phone, so it doesn't meet that hurdle. They are particular to a social media platform. A social media platform that they have to establish belongs to the defendant, and I don't think they have said how they purport to do that. Even if they do that, the statements of anybody else in those exchanges is hearsay. Statements of the defendant are irrelevant, and the photographs and videos are also irrelevant and prejudicial pursuant to 90.403.
Thank you, and I misspoke. It was one opinion. It's a PC affirmed on Benjamin v. State, or Benjamin D. Roy v. State, that you cited, 279 Southern 3rd, 238. It's a PC affirmed. There is a concurrence, and he would concur in part and would reverse in part. I misspoke. All right, so yes, counsel, you want to be heard?
Yes, Your Honor. With regards to, and defense counsel already has the Lamb case, so I'll just provide a printed copy to Your Honor. Specifically, authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proper evidence is authentic. I'm reading on the 9th page with notes 5 and 6. Your Honor. Lamb case goes on to state that authentication for the purpose of admission is the ultimate determination of authenticity of the evidence, is a question for the fact finder. Evidence may be authenticated by appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or by showing that it meets the requirements for self-authentication. With regards to the evidence that's before Your Honor, the defense is not agreeing that it's his account. So then the burden is on the state to prove that it's his account. As such, the evidence itself shows that it's authentic, as it is the defendant in every single one of those videos. In terms of the contents of the defendant's statements, they are relevant. They go to the issue and fact of whether or not he committed these 2 homicides. The contents of the questions are important for giving context. An answer without any context doesn't give the fact finder, the jury, any way to meaningfully evaluate the statements. So based on the standard, which is low for authentication, the state has done that by the business record certification and the fact that the email address and everything else will be linked up in other witnesses as well, showing that that was the defendant's particular iCloud account that is the username. It's also important to note, Your Honor, that while the individual doesn't tie it to a specific device, it ties it to a specific individual because it's a unique logon and username and password, just like an email account, that it was used by this defendant.
Thank you. Anything else, Counsel?
Yes, Your Honor. There are statements there that, in the conversations, that started on October 3rd. October 3rd, this incident occurred on the 26th. The state is making a blanket assertion that these statements go to demonstrate his complicity in these homicides. Each statement has to be identified and the argument has to be made as to each such statement by itself so the court can have a way of evaluating the purported relevance. They can't just say they're relevant to the homicide. That is insufficient. And if they do not identify each particular statement and the relevance of each particular statement, then dumping them all in on some blanket assertion that they're relevant would be error, and it would invite error, and it would prejudice Mr. Demons irreparably. So, context for what? He's having an argument, a discussion with somebody on October 3rd. If they're saying that that constitutes some plan that establishes premeditation, then let them advance that argument. They have not referenced a single one of those conversations with specificity and advanced some argument that ties it to a fact and issue in this case. So I would say that on the relevance alone, the state fails to make a showing that would allow the court to even properly analyze the question at issue.
Thank you. I'm going to defer ruling out. Take a look at your cases that you just sent. We're going to take a short recess. Mr. Demons, you need a restroom break? Yes? Can you arrange for a restroom break? We'll be in recess. Thank you. Jurors in the jury room. Counsel, I've had an opportunity to take a look at your cases and read over a little bit more about Snapchat. And my thought is this, I understand the defense objection not be admitting it, allowing the evidence to come in. However, there's a couple caveats. Number one is, one of the videos I saw has a gun in it. This is all.
Shows access to the murder of firearm 6 days before the homicide.
Right. I don't see how that is relevant to anything, and I think it's more prejudicial and probative, and it shouldn't be there, all right? So I'm not allowing that weapon. It's not like you had something 15 minutes or a half hour before the incident in question. I'm not letting something with a gun days before. That's number one. Number two, I know there's been no argument the 403 analysis, but I don't see how any of the pictures and the videos with all the flash and the cash and all that really has anything to do with anything. I want all those out. I'm not admitting those. All right?
So the videos of him in the bathroom with the stack of cash.
Anything where he's flashing all the cash, I don't see how any of those things are relevant. They're more prejudicial and probative. The gun is more prejudicial and probative. I'm not letting it.
Okay, so what I'll do, with your next permission, is I will pull them up here and verify them. Because then I would be changing the business records on that. So, but that's important with your honors roll. So that would be these 3 videos in the bathroom. Judge, with regards to this particular video, the second video doesn't have the defendant's picture in it, so just so it's clear. So and so, Your Honor, what I would suggest is that I can modify that video to take out the part where the gun is there, and then, so it would just go from there and then excise the portion where the gun is shown, because that is showing who is speaking and showing who is then showing the driver's license.
It's fine. The gun should be out. It's not.
Your Honor,
staged before.
Could she at least articulate the relevance of anything? I mean, I understand.
I heard your argument. I understand it.
Okay.
And I've overruled it.
It is overruled.
Overruled. The only thing I'm doing is on 403 analysis saying that you can't, I don't see the relevance, I don't see the probative value of the gun and the cash being outweighed by overruled.
Defense counsel is also asking to take out the photo of the song and their titles or whichever else.
Right, I agree. Take it out. Murder on my mind. We'll be in recess. You work on it. Yes, sir, you want to say something?
Yes, Your Honor. So has the court articulated its ruling concerning the visual images, the videos and pictures, or has the court also decided that all the communications come in without the state asserting a relevancy objection as to each state, or a relevancy as to each state?
Counsel, the videos, my understanding, the videos as well as the written conversations, are you articulated and objected, saying they're not relevant and they can't be authenticated, things like that, and the objection is they can't be authenticated. We don't, because how Snapchat works, anybody could have done it. And counsel's suggesting to me that she needs to put it in to show that it's his, because he's the one that's picture on those accounts. It's authenticating. I know I'm the determination of what's authentic, whether it's authentic or not. I'm making that decision. But it appears to me it's going to be argued that it's not his account, or he's not the one that's putting this information on there. That's the tenor of what you're suggesting. So it just seems to me that goes to show who's on the account and whose account it is.
No, I understand that, Your Honor, and please do not understand me to be arguing a decision that the court has made. I'm trying to understand that saying that we're going to put all this in to prove, we're going to put in all these conversations to prove that it's his Snapchat account. Why are they trying to prove that it's his Snapchat account if not to get the very statements in? So if the statements themselves are relevant, saying, well, we're going to put in these statements to prove it's his Snapchat account, should they at least articulate why are you trying to prove that it's his Snapchat account?
Because there's a statement in there which there's the state believes is an admission.
Okay, well, if that is the case, then that statement should come in, and if those statements are isolated, then the defense would be in a position to determine whether or not they're going to take the position that it is not his Snapchat account, and do a 403 analysis of our own. So if they're saying there are 3 statements in there that constitute admissions, fine. If they might want to put those in, and we might say, okay, we're not going to contest that it's his account, so you don't have to put in all the other stuff that is prejudicial. But they have to at least articulate it and isolate it so that we can make an informed decision.
Thank you, counsel. You didn't bring up the fact that it's overly prejudicial. You had a straight relevance objection and authentication objection. I've overruled those objections. When I looked at the video, I said, nobody else, I said, I think that's too prejudicial, not probative of anything, the picture of him with a gun, and I want it out of there. I said the same thing regarding the cash. You did tell me, and I didn't articulate it, that you were concerned about the video with murder on my mind, and I agree with that. That should be out as well. All right? Okay. So that's the ruling. It's the relevance objections overruled. The authentication objection, I admit it, but I don't want the items that I previously discussed being shown to the jury.
Thank you, Judge.
Here, if I may have a moment to show defense counsel the clip as it's been
You go
edited.
ahead. We're in recess for a minute.
Thank
Show whatever you want to show.
All the other ones are already taken out. This is the other one to take out the gun.
It's a date of these so-called videos on.
Yes, they are on each specific one.
Could I see that diagram again?
Yes, it's there.
Yes.
I want to know what
You're in recess.
the purpose of this is a Snapchat account.
Snapchat.
Can you at least identify what you think is a confession in there? Identifying, but I don't understand why you would not identify it, because then you might not have an objection to the rest.
But you probably still want to know.
Yeah, but then it would be invisible based on her theory. I'm not concerned about that. The judge said take him out, take him out. If you take him out, don't take him out, then. I don't need to say.
And anything else that's an admission to census code? No.
No, I'm going to take the position that if you think there are confessions in there or statements that implicate him, identify them. This is the only one.
This page. On November 9th.
No.
On November
You're
9th.
telling me what I'm saying. I'm saying identify what you want in. Because you think it's all admissible to prove that it's his account. If we're not contesting that it's his account, then you're putting in informed information. Identify what you want in so that we can make an informed decision. If you violate the judge's order, then it's a you problem. I don't need to review it.
Can you make these copies? I know you gave it to them.
Yes.
Okay. I'm not trying to make everyone. I know you have them. It's just problems.
Council's gonna take you a few minutes.
The video's
Yes, we
done.
need a few minutes. I think Mr. Allison is taking a pizza. And we just wanted to be clear that if we
We're in
are,
recess now, so you want to be on the record again?
yes, just so I can complete the record on this one point.
Let the record reflect the presence of the defendant, his counsel, the assistant state attorney, jurors, and juror. Yes, sir?
The state is asserting that among the conversations in state's exhibit, what was it, mark for identification?
J.
Triple J, that there are certain conversations or certain exchanges which she believes relate to facts at issue, and that the rest of them she is using to authenticate or to establish that it is the account of Mr. Demons. I'm just putting on the record that the defense would be willing, if she does isolate those conversations, to consider not objecting or not making the claim that it's not his account, so that she can get in whatever she deems is relevant, and we can avoid the prejudice of the remaining contents that she intends to put in that is not relevant, and she only intends to put in to establish that it's his account. I just wanted it to be clear that that is an offer that we have tendered to the state, and we're articulating for the court. Thank you.
Thank you. What says the state?
Your Honor, the state is going forward that the state has to convince the jury beyond a reasonable doubt as to the authenticity and who those messages link to. And that was the way defense counsel indicated from the beginning that that is how the state needed to proceed. So at this point, the state would enter the evidence as it is currently put.
Thank you. Can you please consider, I mean, there's whole conversations with Ms. Mariah Hamilton that really, I mean, that goes to authenticate the, whose account it is, but I don't know that it does anything other than that. And Can I see the exchange again, please? JJJ?
Oh, I left it right there, I'm sorry.
And Mr. Edelstein asked me to print another copy for him, so I'm trying to work on that.
I'm sorry.
I apologize.
No, it's my fault, I accept the responsibility. For the court, I get 2 or 3 points off my guidelines.
Let's get back on the record. Again, let the record reflect the president, defendant, his counsel, and the assistant state attorney, jury in the jury room. I'm not fully understanding everything that you're saying, Mr. Howard. You're telling me that you're not objecting to the Snapchat conversations, and so you're not going to argue to the jury in some way, shape, or form that's not him if it's limited to what the state is suggesting, so the conversations between he and his girlfriend and things like that wouldn't come in. Is that what you're saying?
I am saying, Your Honor, that if we need to be able to make an informed decision. So I am saying that we need to know what she deems to be relevant, and then when we know that, then we can make the decision that, okay, well, we think that it makes more sense to not make the argument that it might not be his account,
okay,
so that she can get her evidence in, but to get the rest in. Your Honor,
no problem. We'll just leave it the way it is.
Okay. There may be another issue, not as though you don't have enough on your plate here. We have reason to believe that the state intends to call Miss Felicia Holmes in this next session. And there is the law in this jurisdiction and in this state is that a witness shall not be called merely to be impeached. I don't know that that is the case or not, but I'm concerned with trying to unring a bell. The theory is essentially a statement that the state knows that they will not be able to elicit, and they seek to only impeach their own witness by a prior inconsistent statement, amounts to hearsay because it's being offered for the truth of the matter asserted. So when the state calls a witness that they know is about to, and these are instances when a witness says A and then recants and says B, and the state wants to get A in and knows that the witness's current position is B. To put the witness up there to say B and then impeach them with A is improper. I have here some cases, a few, for the court, stands for that position. Dudley v. State, 545 Southern 2nd, 857, Florida Supreme Court, 1989. Felton v. State, 120 Southern 3rd, 126, Florida 4th UCA, 2013. Curtis v. State, 876 Southern 2nd, 13, Southern 2nd, 13, and that's 1st VCA, 2004, and there are many others. And may I hand up? I have highlighted copies of the cases.
You have them for state as well?
I do indeed. If I may.
Take a look, whatever you have.
Thank you, sir. Now, I understand that this might be a little bit premature to the extent that I don't know for what purpose they seek to call Ms. Hamilton, but I don't want to be in a situation where we're trying to unring a bell when we are in a position to avoid that prejudice from occurring. So I'm alerting to the court to that possibility, and if that is in any way the state's intention, I would ask that it be voiced now so that the court is in a position to make that assertion. And they don't even need to voice it to us. They can voice it to the court outside our presence.
And who's your next witness?
Felicia Holmes.
All right, so it is Ms. Holmes? And
Not Ms. Hamilton.
Felicia Holmes, sorry.
And what do you anticipate Ms. Holmes say?
Judge, I believe she will testify consistently with her previous statement that she gave in 2018. And I'm very familiar with the case law, and I would agree with counsel that the state cannot call a witness just for the purpose of impeachment. However, I'd also direct Your Honor's attention to 9803 subsection 5, past recollection recorded, in which a witness who no longer has a memory of an event but has previously given a memorandum or record as to what happened, they may testify as to lay a predicate as to that, and then that memorandum or record could be read into the record in support thereof.
So are you telling me that you believe that your witness is not going to remember what you said previously?
I believe there are instances in which her memory is no longer available, and that she would testify that she was truthful to law enforcement at the time of the statement in December of 2018, that she now no longer remembers because it has been so long, and that was a time when her memory was better. It was closer in time to the time of the offense. It was within 2 months of the offense occurring and the events of which she witnessed, so that would be admissible under 9803 sub 5.
So you're telling me you've spoken with her, you had a pretrial discussion with her, and she said she has no memory of what she said at the time?
There are parts of which the statement she does not recall. That is correct.
May I retort?
Sure.
Okay. A couple of things. One, as with every other witness, the way that you prepare your witness is you refresh their recollection before you call them to the stand. So the notion that this witness is that all the state has been able to glean is that Ms. Holmes no longer recalls something which she said several years ago, and the state has not sought to refresh her recollection, in which case she would have been prepared to testify, then the pretext that she comes in here and says something different and then she impeaches her with a prior consistent statement claiming that it's an effort to refresh her recollection is disingenuous and in bad faith. And if that were able to be done, then this body of law would not exist. We also took her deposition, Ms. Holmes, on December 14th of 2022. No, that's not it. Much more recent than that, no?
22. Yeah.
December 2022, in which Ms. Holmes receded from the statements to which the state refers firmly and unequivocally. And the state is therefore, I think the language used in a lot of the cases that I have cited and in a lot of cases on the subject is the state needs to be surprised during the course of its examination at the contents of the statement in order to thereafter impeach their own witness. This notion that, oh yeah, well, she forgot, and while we talked to her, we learned that she forgot, and instead of refreshing her recollection, as we did with every other witness that we put forth prior to in preparation for her testimony, we're going to wait and do it on the stand by impeaching her with a prior and consistent statement it's a pretext, it's in bad faith, and it's improper. It's prejudicial, and it should not be permitted. Essentially, it amounts to hearsay, because it's a prior and consistent statement, or an out-of-court statement that is going to be used to prove the truth of the matter asserted, which is different from impeachment, where it's not used to prove the matter asserted, it's just introduced to prove that you said something different at a different time. I think these cases are clear. And if that's what they intend to come and do, again, they're inviting error, and I'm alerting the court and the state to it before this miscarriage of justice ensues.
Thank you. Anything else, madam?
Just the record's clear in her deposition and counted. She says, I don't remember, or I can't remember, approximately 26 times. The witness has been reviewing her statements and depositions for the past 2 days, and she still persists in saying she does not remember, so that 980305 would be an appropriate remedy to enter the testimony from the prior statement.
By the way, Your Honor, I've highlighted those cases for ease of reference. Or at least 2 of the 3.
And what's her statement, counsel?
What is her statement?
Right.
This was previously provided to defense counsel.
Oh, just give me a synopsis.
Yes,
What is it that you want, or what you believe she's going to testify to, or if she doesn't remember, what you are going to try to refresh her recollection?
So she says that she was woken up at 4 in the morning. Her daughter was screaming. The daughter was on FaceTime with Melly. Mr. Dimmons then says he was saying that meaning Mr. Dimmons was saying that someone just shot the car up and was trying to shoot them. He then said there's like a car coming behind them and he's hiding. So then she asks Mr. Dimmons, "Are you okay?" His response was, "I'm okay." She then asks him where are Sack and Juvie, the common nicknames of the 2 victims, and he said, "I don't know if they're in the car. I think they're dead." So she then says, you think they're dead. She then goes through and describes her actions and conduct. She said that she called his mother, Jamie. Oh, I wouldn't go into the contents of that conversation because that would be hearsay. She then describes what she sees, which was her daughter on the phone on FaceTime with Mr. Dimmons. She then says that she's going to come down, and then she describes her actions, that she hopped in the car and came down to South Florida. She said that at that point she asked and called Mr. Dimmons again, spoke with him and said I'm at my friend Fredo's house. Fredo picked me up, so we went to Fredo's house. Then she describes that Fredo lives over in the same neighborhood that Melly lives in, and that she went in through another gate from the same neighborhood on that one. She then says later, shortly thereafter in her statement, when they get to Fredo's house, that Melly comes out and he takes Mariah and they go upstairs at Fredo's house. Then she also goes through and indicates that after this incident, that Mariah, her daughter, Mr. Demons, Cortland Henry, and Cortland Henry's girlfriend are living together in a condo in Miami. She's going to testify that she didn't, and the statement also says that she didn't see any blood or anything on his clothes or anything like that. The questions asked then about her being FaceTimed, meaning Mariah Hamilton, the daughter of Felicia Holmes, FaceTimed, and her answer at that point was, he FaceTimed my daughter from the 772 number. So then she continues on, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 in the morning, yeah. Then she's asked, what's her daughter's number? And she gives her daughter's phone number at that time, 321-506-1313. Then it continues on, and so the law enforcement officer asks and says, I have his phone records, meaning that of Mr. Demons, and he never called, there was never. Then she identifies the phone number as, you have the 772-713-9807 number. She then continues on, he called and FaceTimed with, I talked to him on FaceTime. Then there's another incident, I don't know if potentially this could be possibly admissible, depending on the testimony. She says that they told me there were other guys in the studio, and he was saying that the other guys got mad, but they never said who was at the studio.
But you're telling me, counsel, that you spoke with the witness prior to, and the witness is not saying she didn't say X, Y, and Z. She's saying she doesn't remember.
Correct.
The incident.
In the presence of the witness and her attorney.
Thank you.
Your Honor, before I address the specifics there, I just want to put into the record some of the language that I think is most pertinent. In the Curtis case, 876 Southern 2nd 113, which is a First District case in 2004. This is the language. It says, Florida allows litigants to impeach their own witnesses, but that does not necessarily resolve the constitutional problem identified in Chambers, which is another case that's referenced. Although a witness may be impeached in Florida by any party, including the party calling the witness pursuant to Section 90.608 Florida statute, it is still improper under Florida law for a party to call a witness merely as a device to place the impeaching testimony before the jury. That is Curtis. In the Florida Supreme Court of Dudley, the language that we're relying on, the case says, one major issue requiring our consideration concerns the calling of Robert Bennett as a court witness and the presentation by the state of his prior inconsistent statement as substantive evidence. There's language further down that says, in a similar situation, the First District Court of Appeals in Austin v. State 461 Southern 2nd 1380 Florida 1st District 1984 found that although a witness's hostility towards the parties may justify the trial court's exercise of discretion in calling the witness as a court witness, call a witness only to elicit prior unsworn statements for the purpose of proving the truth of the prior statement is error. The district court stated, under the circumstances of this case, it was impermissible to use the expedient of calling the witness as a court witness under section 90.615 for the purpose of eliciting his prior inconsistent statement, either for impeachment purposes or as substantive evidence. To conclude otherwise would permit indirectly that which may not be done directly. Further language from that case says the fact that a witness may be hostile or unwilling does not mean that he is adverse. In order to be regarded as adverse under this section, the witness must give testimony prejudicial to the cause of the party calling it. So if you know that's what's coming in to begin with, there is no surprise. And then in the Felton v. State, 120 Southern 3rd, 126, 4th District, 2013, the language that we're relying on says, in Ruff v. State, 31, Southern 3rd, 833, Florida, 4th DCA, 2010, this court explained, our Supreme Court recognized that consistent with federal precedent, a risk of abuse occurs when a prosecutor calls a witness who has previously given a statement implicating the defendant, but who has since repudiated that statement. In such cases, the purpose of calling the witness must be examined along with the balancing analysis under Federal Rule 403 to weigh the prejudice over the probative value of the evidence. Generally, however, if a party, and that's citing to Morton v. State, 689, Southern 2nd, 259, Florida, 1997, that was receded from on other grounds. Generally, however, if a party knowingly calls a witness for the primary purpose of introducing a prior statement which otherwise would be inadmissible, impeachment should ordinarily be excluded. That is exactly what is taking place here. There's no failure of recollection. If the state, first of all, if somebody gets a call at 4 in the morning concerning a murder that occurred, you don't forget it. This notion that she forgot and she is now going to refresh her recollection by reading a statement into evidence that is impermissible, hearsay, is a pretext, and it is a 403 violation, and it is a violation of well-established law in this state that I've just articulated. And if the state was unable to refresh her recollection of such a significant event during preparation, the notion that she is now just going to read the statement into evidence on some pretext is a miscarriage of justice. If she has a witness, she has a witness. If she doesn't, and she knows she doesn't, calling the witness to impeach them by essentially introducing hearsay testimony is improper. The deposition that we took made clear that she she was receding from the statements that she made, and she gave explanations for why she made statements that she made. This is not a situation of failing recollection. This is a situation where they're trying to put in impermissible evidence under a pretext, and we object.
All right, anything else? Madam State?
No, Your Honor.
So we're going to bring the jury in, we're going to see where it goes. All right, I understand what the objection is. God bless. I understand what the objection is. We'll see where it goes.
All right.
All right, let's bring the jury in.
No? I don't have
But those aren't the same statements that we're looking at.
No, we don't have phone calls, she's going to.
Sure. Your Honor, I'm not sure we're ready for the jury. We're being handed totally different information that they plan to
Gary, hold on.
put in through this witness.
I'm sorry, what were you handed, counsel?
Counsel has been handed and was previously provided in portion of the defendant's phone extraction. This particular summary, and there was a notice of intent to rely on summaries filed prior in this case by the state. This particular summary details the conversations between the defendant under the 772-713-9807 phone number, conversations with Mariah Hamilton, the witness's daughter, and her cell phone on that, as well as conversations with Miss Holmes herself, who is a party to some of these conversations. There was a group chat going on in which she is able to authenticate that the phone number, the 772-713-9807, which is reflected in those records, was being used by the defendant at times before, after, and during the homicide in question.
I take it these are just being introduced to identify the 9807 phone number
As well
as being a phone that Mr. Demons used.
Correct. So, and if there are two first pages, because if you look at them there's a section in green where he's telling Miss Hamilton this will be his third birthday he's been locked up on. I agree that that would be prejudicial to the defendant, so I created a version in which that specific item is taken out. So if you look at the green birthday and then just take the first page and the second page, or if you look at one another, with the exception of that alteration.
I'm not sure I understand. It sounds like you're saying these are conversations that took place while he was incarcerated?
No. He knew and was was made aware he was going to be serving a sentence in Lee County, because that was a negotiated resolution. So instead of saying third birthday I'm going to be locked up on, WTF, instead I just put third birthday and then her response on that.
To the extent that Ms. Holmes is not a party to the conversations, she can't authenticate. Now, I understand the state is saying that there are certain conversations which were a group conversation between Mr. Demons, Ms. Holmes, and Ms. Hamilton.
Correct.
Are all of those, do all of the conversations in that exhibit fit that description?
No, she's also identifying her daughter's phone number in this other one.
Identifying her daughter's phone number, Your Honor, doesn't identify the participants of a conversation.
And so here are the other ones in which, for example, there is other participants in which her daughter's phone number is included with the defendant, the 9807 phone number, the manager's phone number, the little brother's phone number, the phone number of Miss Janie King is on there. Then there's the phone number down here as part of the third part, where it is the defendant's phone number, Miss Hamilton, and Miss Holmes that are all listed on there.
And the state has not articulated a relevance of even establishing Ms. Holmes or Ms. Hamilton's phone number. For what purpose? I think I heard the state indicate a little while ago that there was no record, according to the detective, of this alleged phone call. So it's not as though they're going to say, see, here's a phone call between this number and that, because they don't have a record of it. So establishing the phone number, for what purpose? They might as well establish my phone number. What does it matter? If it can't be tied up, or if it's not going to be tied up to some other record that they have. Saying that we want to put it in to show her phone number. Show her phone number for what? What does Ms. Hamilton's phone number have to do with anything? They can proffer it, but they have not yet articulated it. And there's several phone conversations there that do not involve the witness they're about to call, and for those phone conversations to come in through that witness is just improper. How does she even lay the predicate for that?
Yes, ma'am, I don't know what you're trying to do.
So in terms of authenticating the phone numbers and laying the foundation for when these come in later on, I don't intend to publish these at this point. This is a predicate question that has to be established by this witness to show the phone numbers, the participants, the identity of those individuals, and some of the items in them.
When you say participants,
Correct.
does she know who the participants are? She's a party to this?
She is. She is one of the parties. For example, one of the specific items that's talked about is the defendant killed a pet. It was a snake that died. She knows and knows who had that snake, the circumstances of how it was killed, so she can authenticate based on the content who was on the other side, who was using that phone. The point of contention is who had the 772-713-9807 phone number at the time of the homicide.
Okay, thank you. All right, so we're going to just see where it goes. You make whatever objections you think are appropriate, Counsel.
Okay, sir.
Thank you. Sorry, something funny?
Pardon me?
Something funny?
Not at your ruling. Your Honor, I mean no disrespect to you. And I hope you don't get that impression.
Let's bring the jury.
Thank you.
Jury entry.
Ladies and gentlemen, thank you. Please be seated. Let the record reflect the burdens of the defendant, his attorneys, assistant state attorney to the jury. Ladies and gentlemen, I apologize for the delay. My fault, not anybody else. I apologize for that. In any event, I think we're ready to proceed. So, Madam State, want to call your next witness, please?
State will call Felicia Holmes. And you're at this time, the state offers state triple J, which was previously shown to defense. And your 9803.6 is a business record. And request.
Any additional objections, counsel?
No additional objections, but objecting on the ground.
Thank you. To be admitted.
Thank you.
Stage triple J will be marked stage 61.
61?
61. Thank you.
Counsel, where's your witness?
They were down the hall. With your permission, I send you a text message, Your Honor?
Yes. morning. Are you Ms. Holmes?
Yes, I am.
Welcome.
Hello.
Come on up here. This is our witness stand. Ms. Holmes, when you get there, what I'd like you to do is remain standing. Raise your right hand and be sworn. You get the first time. Thank you. Raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you should give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your full legal name for the record.
Felicia Ashe Holmes,
Please spell your first and last name for the court reporter.
Felicia, H-O-L-M-A.
Please have a seat. Ms. Holmes?
Yes, sir.
That microphone in front of you does not move back and forth. It will just up or down, but not back and forth.
Okay.
You ready?
Yes, sir.
Counsel, you may proceed.
Thank you. Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamel Denons, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I'm thinking maybe 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Denons?
Yes, I did.
What did you refer to him as?
I call him Jamel Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Here, I made a record reflect court identification of the defendant.
Yes, the record will reflect an in-court identification of the defendant.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to that?
A couple.
A couple?
Maybe two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't. No.
Okay. Did you know if he had social media at that time?
I didn't. No, I didn't.
Okay. Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry?
What was your social media name?
My name? For which one?
For Instagram.
Instagram, it's like Bling Queen 258.
Okay. Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
Okay. What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Okay. Did she have Snapchat?
I'm pretty sure she did.
Okay. So I'm going to show you what's been already admitted into evidence as State 61. There's a couple of videos and things on that I would like to ask you to ask some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material.
Thank you. Objection noted.
So I'm showing you what is titled Memories 2018 October 9th 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter.
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Chanel.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter Mariah.
Do you recognize the individual in the back?
No.
Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Stack maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Stack and Judy.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. Start with this one. I'm going to.
So all that extra shit, and like, they leave the most important shit here. Then,
So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one
the most
here.
important shit here. Like, it right there, like, you know you come back.
Whose driver's license is that?
That's my daughter.
The conversations and things that on there, do you recognize the voice?
I didn't really, this, I mean, you have to play it again.
Sure.
Before we tell me, all that extra shit, and like, they leave the most important shit here. Then,
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Jamel.
Okay. So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Have you met her prior to October 26th of 2018?
Yes, I did.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was she? What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, you remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. But I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So, in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter and take her to jail for accessory after that. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection asked and answered. Excuse me, overruled. Repeat your question.
I don't remember.
Excuse me.
Yes, sir.
Only one person can talk at a time, and there was an objection. I just wanted to be clear. All right? You asked your question again.
Okay. So, Ms. Holmes, Did you lie to law enforcement?
Not that I recall.
Oh.
I don't remember.
Okay, going forward to the events of that day.
Yes.
When you heard that phone call, where were you?
I'm home.
Okay. Where was home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assumed it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, did you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So, Ms. Holmes, to go back in terms of looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, could you repeat the question?
Sure. You said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as to what?
No, I don't think it would.
Okay. Would you like to try to do so?
You have to look at it for you, sure.
Okay. And so, counsel, on for the record, I'm showing for page 3 of 8. And I'm going to ask you, Ms. Holmes, to just read this part silently to yourself. Okay. And I'm going to read from, we're going to start here, this, and through here, okay? Silently to yourself. When reviewing that, does that refresh your recollection?
No, it doesn't.
Your Honor, pursuant to 90.8035, the state would move at this time to read into the record the relevant portions.
Objection, Your Honor.
Can I see, please?
Yes, Your Honor.
Ladies and gentlemen, it's 12 o'clock. Let's take our lunch and recess. Don't discuss the case. Don't film any opinion about the case. Don't allow anyone to discuss the case in the presence. And certainly no research, all right? Please rotate on your chair. Sorry for the delay. What time? Let's say 1:30. Thank you.
Oh, sorry.
Okay, thank you.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, assistant state attorneys, and our witness. Madam, you want to step outside for a minute? Thank you. Just wait outside. Thank you. So what do you anticipate this?
That her answer would start with, he FaceTimed my daughter from the 772 number. Question, yeah. Answer, unless he got rid of that phone. He FaceTimed my daughter that morning at 4 a.m. in the morning, yeah. Question, what's your daughter's number? Her number is 506-321-506-1313. But she may have another number because I changed her. She lost her cell phone and got another number. Her old number was, question, no, cuz, answer. Her old number was 877-9609-321. Question, no. See, I have his phone records and you know, he never called it. There was never, answer. You have the 772-713-9807? Question, 9807. Answer. I don't know whose phone that he called and FaceTimed with. I talked to him on FaceTime.
So, assuming that I let this portion in, is this going to be a reoccurring theme? That what else are you going to ask her about?
In terms of that, as well as the initial part where she says she doesn't recall what he said verbatim. That would be the part where he's saying that someone just shot the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's a car coming behind him, like hiding. He was like, there's some, yeah, he's like, yeah, there's some, I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Sack and Juby? And he said, I don't know if they're in the car. I think they're dead.
And that's the portion that you're looking to have admitted?
So far, based on her current state of her testimony up to this point.
Is there anything else?
If there's anything else that she doesn't remember on that, for example, the Frito Bang or Frederick Gibbons is his actual name, aspects of that, anything about the condo in Miami, about the blood on the clothes. There's another part later on where she then describes the conversation again that he said. He just basically said that his friend they just got killed, and that he was like, there was lights coming, somebody's coming, someone's coming. I'm like, are they still out there, you know? Question, answer. It's like I don't know. And I said, we're on our way, just so you know, stay put, we'll come get you. So at this time, I'm thinking he's somewhere hiding in the bushes somewhere from whoever shot him.
And the statement goes on, there's other things that you're trying to get out through this witness that you're concerned she may or may not remember?
Those are the relevant portions, Your Honor. There's a lot of other things that she indicates in the statement that I would agree would not be relevant, and that wouldn't prove an essential fact that is at issue in this case. So I would not be seeking to insert the entire statement.
Basically the portions that you just elicited.
Yes, Your Honor. And I can I have the ability to, in a Word document, to isolate those so that they can be succinctly read, provided to defense as well, so they would have copies. But the case law is clear and the statute is clear. The state cannot introduce that statement, but defense would be able to if they so chose.
Thank you. And your objection is?
Your Honor, we have a copy of her deposition, which makes clear.
Can I stop you for a second?
I'm sorry.
What is counsel reading from now? What are you reading from now?
I am reading from her statement of December 12th of 2018.
You're reading from the statement, not a deposition?
Correct.
Thank you. I'm sorry. Go ahead.
Thank you. And before I go any further, Your Honor, I meant no disrespect. And I appreciate your and understand your authority, and you're making decisions. Whatever reaction I had was not intended to convey disrespect, whether I agree with your decisions or not. Her deposition of December 14th, 2022 will clarify the issue of whether this is a failure of recollection that the state is trying to refresh, or whether or not this witness has recanted her statement and is making an entirely different statement about the facts of that night. In this deposition, she is not claiming not to recall. She said she wasn't certain about the time of the call, but she quickly got herself together and came down here, and it took about 3 to 4 hours, like she said, and she got here around 12 or 1 o'clock, which would place that call at 8 or 9 o'clock in the morning. There are several other substantive statements that indicate that she is recanting that statement she gave on that day. She says the reason that she gave the statement was because her daughter was threatened with arrest, like she said here. she said that she feels threatened, and first thing she said there, she's not talking about Jamel, she's talking about the state. She's on an ankle bracelet. They arrested her in the Virgin Islands and brought her over here. And the statements she's making in her deposition do not support and are I wouldn't say they contradict, but they're not the statements that are made in the statement that the state seeks to elicit. If the rules allowed her to put a witness on just to get in a prior statement, then they'd be in okay territory. The rules don't permit that. She's creating this pretext. Oh, you forgot that? Well, let me read it into the record. I would offer the court a copy of this deposition over lunch to review that makes it clear that she is recanting. She is not forgetting. She is recanting. And that's exactly what these cases speak to, and the process that the state is, what they're attempting to engage in is to violate and circumvent the rule and admit out-of-court statements for the truth of the matter asserted, which are hearsay, which are recognized to create constitutional problems, which have resulted in some of these cases and murder cases being reversed, murder convictions being reversed, and she's inviting error into this court, into this trial, and we'd ask the court to at least get a context of what is going on here, whether this is a failure of recollection, whether that's the way she's fashioning it, or whether or not what she said in her deposition does not comport with what she said in that statement that she's recanting, and whether the state is just using this rule as a pretext to get the statements that they're not permitted to get.
Thank you. You have the statement of Ms. Holmes as well?
I do, Your
And
Honor.
that was taken under oath?
It was, yes, it's a sworn statement from Ms. Oath, from Ms. Holmes in December of 2018. And Your Honor, I would also add that some of the time frame and issues of that, those were actually clarified because defense provided the state with reciprocal discovery of Ms. Janie King's phone records, which authenticate the statements, for example, that Felicia Holmes said she immediately called Janie King. That is shown in Ms. King's phone records.
Who's Janie King?
The defendant's mother. So there's outside sources that corroborate the sum and substance of her December 2018 statement.
All right, so I'm going to take the statement. If there's no objection, I'll take the statement and the deposition. I'll read those over lunch, and then see everybody back here at 1:15. I told the jury to be back at 1:30. We'll resolve those issues, and we'll move forward. All right?
Thank you, Judge.
Thank you.
Romantic relationship with someone named Jamel Denons, also known as YNW Melly.
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it may be about 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Denons?
Yes, I did.
What did you refer to him as?
I call him Jamel Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your Honor, the record reflected in court identification of the defendant.
Yes, the record will reflect an in-court identification of the defendant.
So in October of 2018, Had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to that?
A couple.
A couple?
Maybe two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't. No.
Okay. Did you know if he had social media at that time?
I didn't. No, I didn't.
Okay. Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry?
What was your social media name?
My name? For which one?
For Instagram.
Instagram, it's like Bling Queen 258.
Okay. Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
Okay. What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Okay. Did she have Snapchat?
I'm pretty sure she did.
Okay. So I'm going to show you what's been already admitted into evidence as State 61. There's a couple of videos and things on that I would like to ask you to ask some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material.
Thank you. Objection noted.
So I'm showing you what is titled Memories 2018 October 9th 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter.
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Chanel.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter, Mariah.
Do you recognize the individual in the back?
No.
Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Zach maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Zach and Judy.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. Start with this one. I'm going to.
All that extra shit in like, they leave the most important shit here.
So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one here.
You know you come back.
Whose driver's license is that?
That's my daughter.
The conversations and things that on there, do you recognize the voice?
I didn't really listen. I mean, you have to play it again.
Sure.
Before we tell me, all that extra shit in like, they leave the most important shit here.
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Chanel.
Okay.
And so that was just a portion of the testimony from Felicia Holmes, the mother of the defendant's ex-girlfriend there. Sonny, I'm going to start with you here. Felicia Holmes mentioned at the beginning of her testimony that she felt threatened. How would you assess that, and what could a jury be reacting to hearing that?
I think when she said that, and as I heard her say that, I think she was scared about testifying, scared that she might suffer some repercussions from that. And the jury's probably wondering, why would she say those particular words? Why does she feel like her life might be in danger? And what is it that has happened prior to her saying that, or prior to this incident, that makes her feel so threatened? Either her presence, his presence, or what is really going on. So I think that's worth them unpacking later on.
And Bob, do you think Holmes comes off as a reluctant witness here?
In the beginning, she doesn't. She seems to be, very compliant, but there's obviously discomfort that she has in testifying here. So, and as she's going to get walked through these tapes and what apparently are admissions relating to this crime that the defendant's charged with, and the gang overtones that are behind the scenes of this trial, whether they actually come in or enter the trial is another question. Those are things that I think the jury's going to look at, because demeanor, credibility, and what weight to give that are going to be very important in terms of what evidence they're going to accept and how heavily they're going to rely on it.
Yeah, I certainly felt she gave off some type of vibe that she was a little hesitant and holding back on how she really felt with the whole situation. All right, we're going to have to take a quick break here, but clearly a very busy day in court in the Melly trial. Keep in mind that we are going to have a Q&A session as well on this trial coming up around 12:30 p.m., so that's soon. So get your questions ready on social media. We'll be right back with more. You're watching Law and Crime. back. We are covering day 4 of the trial of YNW Melly in South Florida. The rapper is accused of double murder for the 2018 shooting deaths of 2 of his friends, Anthony Williams and Christopher Thomas Jr. Let's head into that Broward County courtroom to hear more testimony now from Felicia Holmes.
So let's go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Had you met her prior to October 26th of 2018?
Yes, I did.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. But I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So, in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Because 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Excuse me, overruled. Repeat your question.
I don't remember.
Excuse me.
Yes, sir.
Only one person can talk at a time, and there was an objection. I just wanted to be clear. All right? You asked your question again.
Okay. So, Ms. Holmes, did you lie to law enforcement?
Not that I recall.
Okay.
I don't remember.
Okay. Going forward to the events of that day.
Yes.
When you heard that phone call, where were you?
I'm home.
Okay. Where was home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assumed it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, did you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So, Ms. Holmes, to go back in terms of looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, could you repeat the question?
Sure. You said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as to what?
No, I don't think it would.
Okay. Would you like to try to do so?
You have to look at it for you, sure.
Okay. And so, counsel, on for the record, I'm showing her page 3 of 8. And so I'm going to ask you, Ms. Holmes, to just read this part silently to yourself. Okay. And we're going to start here, this, and through here, okay? Silently to yourself. When reviewing that, does that refresh your recollection?
No, it doesn't.
Your Honor, pursuant to 90.8035, the state would move at this time to read into the record the relevant portions.
Objection, Your Honor.
And so once again, that's a snippet of testimony from Felicia Holmes, the mother of the defendant's ex-girlfriend there. And Sonny, I'm going to start with you this time. I asked you in the last block if you find the witness to be reluctant. Now, as we get more into her testimony, do you think she's getting a bit testy and seems unwilling to testify for the state?
I absolutely do. Now that there's clarity, the threat is not coming from the defendant. She believes that her threat comes from law enforcement, the prosecution team, and she does not appear to want to cooperate with them in giving her testimony.
Bob, the witness seems to have trouble remembering details now. What do you make of that?
Well, the jury can look at it two ways. Number one, she's having trouble remembering details, and those are reasonable things to kind of forget over time. Or she's just trying not to be helpful with the, you know, the questioner from the state, the prosecutor.
Sonny, how do you view that?
I view it that she said she had some personal things that happened. Her husband went to jail. That's reasonable, that a lot was going on. She might not remember. I also believe that she is a reluctant witness for the state in this particular case. Maybe not because she doesn't, based on her belief of the defendant, but because of her interaction with this prosecution.
And Melly's looking at her as this is all going on as well, so that could have something to do with it. All right, we have to take a quick break, but stay with us on Law and Crime Network. After the break, we are going to take your live questions on the air with the YNW Melly Q&A that we're going to have. We do want to thank Sonny Slaughter, though, for joining me today. We do hope to see you soon. Great analysis, as always, Sonny. You're watching Law and Crime, everyone. Michelle Yu, and thank you so much for joining us for a special hour on Law and Crime Network for the YNW Melly double murder trial Q&A. Our eyes are in Broward County, Florida for the trial of Jamel Demons, better known by his stage name as YNW Melly. The South Florida rapper is charged with 2 counts of first-degree murder for the 2018 shooting deaths of Anthony Williams, also known as YNW Sack Chaser, and Christopher Thomas Jr., also known as YNW Juvie. The victims and the defendant were all a part of the YNW collective, along with co-defendant Cortland Henry, who will be tried in a separate case. Now, if YNW Melly is convicted, the 24-year-old could be facing the death penalty. While court is on their lunch recess right now, we will be taking your questions live on the air, so please submit them on Twitter, Facebook, and YouTube, Instagram, and TikTok as well, and we will do our best to get many questions answered as possible. And now I'm joined by a very special legal panel. We have Law and Crime Network's Brian Buckmeyer, Law and Crime correspondent Bryson Paul, as well as Support Online hip-hop legal contributor Afi Patterson. Guys, thank you so much for joining me here. This trial is receiving such national attention for many reasons, and there's so many twists and turns and drama. It is day 4 of this trial now. Brian, what has stood out to you thus far?
What stood out to me, I think, is the same thing that stood out throughout the trial so far. I'm trying to figure out where the smoking gun is in this case. Maybe it was the trajectory information where they're saying, hey, YNW Melly was sitting at this seat at this time. We saw a video from the recording studio of him entering the car. The shell casings and the trajectory of the bullet suggest that whoever's sitting here is the one that did it. But other than that, I'm not really seeing that damning evidence that the prosecution promised in their opening that should be playing out in this trial.
And Bryson, many people are talking about the demeanor of Melly after he was seen in the courtroom smiling and blowing a kiss, which the victim's family called disrespectful. How could a jury be reacting to that?
Oh, the jury is acting very mild, not really paying attention to what is going on in the gallery, really just paying attention to the evidence at this time.
And Afi, how would you assess day 4 and what you have heard thus far?
So
day 4 has gotten
I think
even.
Today has been. I think today's been fantastic. I think the defense has done a really great job, especially dealing with the Snapchat information, making their objections clear on the record, making sure that they bring in a first tier law to explain their objections and making sure that they make a beautiful record, I think, in the event of appeals. I think that part has been fantastic for me. I also think I agree with the other correspondent. How is the prosecution going to put the gun in Melly's hand? How are they going to make him the trigger man? I understand their theory. They have promised a lot, but I don't see how they're going to put the gun in the hand. That's what I'm waiting for.
All right, great analysis as usual, guys. We're going to now take questions now from all of our viewers. Please keep them coming. We're going to take a question now from Creeps Cringe TV from YouTube asks, do you think that the prosecution has used the 4 years that they have had Melly incarcerated in the best way to build a case against them, or have failed to come up with more evidence to seek the death penalty? Brian, your thoughts?
I don't think so. And maybe it's stylistic, but this is the way I think about presenting any kind of argument to a jury. I want to be the first one to tell you something. I want to tell you more often than the other person, and I want to be the last one to tell you as well. And what I mean by that is, tell me why he's guilty early, tell me why he's guilty often, and give that last word as to why he's guilty. If a jury is waiting 3, 4, 5, how many ever days it gets to, till we get to the heart of the prosecution's case, you may lose people. You may have people drifting away. You might have people looking at YNW Melly and be like, I would be laughing too at this point in the case, because there hasn't been that hard-hitting evidence that makes me think I'm on your side. You want to get the jury on your side as quickly as possible, and I'm giving the prosecution the benefit of the doubt. I'm sure they have something that's going to come. I'm saying do it now and grab and contain and hold the jury's attention for the rest of the trial. Otherwise, you may never get them.
All right, we have another question now. Bryson, I'm going to let you take this one. This is from Young Baller from YouTube. He asks, how are tensions in the courtroom on day 4?
Tensions are the same as day 3, and it's very, 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 very tense between both sides, both Melly's gallery and both the victim's gallery. The families of the deceased are very upset, very angered by Melly's approach, just his demeanor and while he sits in the courtroom, he smiles, laughs, talks to his mother and his special guests in the courtroom, and prays. And the family of the victims are just are still hurt that their significant others are lost, and just angered by the lack of remorse that he has for them.
All right, Afi, we have another question from YouTube from Renard Preston here. They ask, is it still possible for Cortland Henry to be used as a witness of the state, or would he have already needed to be identified as a witness by them prior to the trial beginning?
Because we know who he is. There's no surprise. He would have needed to be identified from the beginning. But also, if he takes the stand, it's easy for him to just invoke his Fifth Amendment right not to testify, not to incriminate himself. Can I also say about yesterday, you don't want to drown your jury in jargon. I think the gun expert drowned their jury, and there was a comment on it that you could have gotten a certificate in whatever he was discussing, but you don't want to lay it on heavy. You want to talk to me like I'm a 4th grader and just guide me through in pieces that I can understand. That's how you're going to keep me. That's how I'm going to not zone out, and I'm going to continue to be engaged.
Well, like I said earlier, there is so much for this jury to take in, let it all sink in. We're going to see where it goes later after their lunch break. But guys, keep your questions coming. We're going to take a quick break here on Law and Crime. We'll do our best to answer all your questions on the air. Stay with us. We'll be right back. to a special hour on Law and Crime Network here for the YNW Melly double murder trial Q&A. I'm Michelle Yu. Our eyes are in Broward County, Florida for the trial of Jamel Demons, better known by the stage name YNW Melly. The South Florida rapper is charged with 2 counts of first-degree murder for the 2018 shooting deaths of Anthony Williams, also known as YNW Sack Chaser, and Christopher Thomas Jr., also known as YNW Juvie. For the next hour, we'll be taking your questions live on air, so please submit your questions on Twitter, Facebook, YouTube, Instagram, TikTok, and we'll do our best to get as many of those questions answered as possible. Before we get to those questions, though, I do want us to recap the testimony of forensic scientist Tara Helschel. She was a witness for the state, so let's listen to her testimony from earlier.
Did you ultimately have a chance to analyze and go through this SEM process, which is the automated process, and your individual process, in order to come up with an opinion as to the presence of GSR?
Yes.
And what was that opinion? And if you can specify both the left and then the right.
So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and 2 two-component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 two-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay. And what affects the presence or absence of GSR on a person's hand or any object?
Sure. So if there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
Okay. And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results of Cortland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or 3 compounds that you were looking for, and which compounds were present in Cortland Henry's left hand?
Lead, barium, and antimony were present in that particle.
So all 3 components?
Yes.
Okay, and let's move on to stage 60, which was the sample for the G. What were your results? And again, did you also go through the SEM automated process and then your individual characteristic process?
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 two-component particles.
Okay, and what does that mean?
So, like I mentioned, two-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with two-component particles, or any of the particles we look at, if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of two-component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
You got the sample from Miramar Police Department?
Yes.
Specifically, Detective Moretti directed it to you?
Yes.
And when we talk about GSR, or gunshot residue, you're aware that GSR can be found on clothes, right?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection calls for speculation outside the scope of the law.
Well, I don't know that calls for speculation. If she knows she can answer the question, overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
So forensics is going to be key in this trial, and with that as the backdrop, I'm once again joined by a very special legal panel. We have Law and Crime Network's Brian Buckmeyer, Law and Crime correspondent Bryson Paul, as well as Support Online hip-hop legal contributor Afi Patterson. Brian, I'm going to start with you here. What stood out to you in this testimony dealing with the forensics?
That it was pointless. I mean, if I was a defense attorney, after I hear the words from the supposed GSR expert, I cannot tell you if this is GSR or something else. What was the word? All I could say is that it's common. So I would come up and say, Judge, what's the relevance? What did this testimony just do for the jury to tell them whether or not my client, Mr. Demmons, did or did not commit a murder? Even go beyond that. If we're agreeing that this shooting happened inside of a car, and I would have got this out of the witness, GSR travels about 3 to 5 feet, and everyone is within 3 to 5 feet of each other. What's the relevance? They all got GSR on them. But you can't even tell me that. So I would have struck in the entire witness's testimony. I would have turned to the jury and said, sorry, the prosecution wasted your time. I'll try to make up for it down the road.
Afi, did you find this pointless?
You know, I did. And the thing is, GSR is so easily transferable. And it doesn't tell you the source of it, doesn't tell you the origin, just that it was present. And given the situation, anyone could have gotten GSR transferred onto them. So it was pointless. But not only that, the prosecution has brought up a number of witnesses. And if you'll notice, the defense only asks probably 1 to 3, maybe 4 follow-up questions and to me, that shows that this witness is basically pointless. You are just doing a demonstration. So I definitely agree. I don't understand the point except to just establish that GSR was present.
All right, we're going to take some viewer questions right now. Brian, you're up here. Jimmy Rowland from YouTube asks, where are the exit bullet holes that leave the car that are seen in the back seat? Do they exit the vehicle through the front or back to indicate the direction? Was the car searched for gunshot residue inside the car?
So typically when they search for gunshot residue, it's typically on a person's hands or their extremities because they're trying to see whether or not the person handled the gun. I'm not sure, and I don't think I've heard whether or not they tested GSR for the surrounding areas of inside the car. I think that'd be redundant because they've already got the bullet holes. In terms of the trajectory, it's hard to tell just from trajectory alone as to where the bullets came from. But because they're charging YNW Melly with the shooting and not the co-defendant Henry, I believe they're saying the shots come from back to front. And I think if you follow the strings that they're kind of pointing there, you see on the screen, you can somewhat see the trajectory. Where they landed, I think they maybe went through the hood of the car, maybe some fell in or some were still within the decedent's bodies.
All right, Bryson, you're up here. Melly Innocent from YouTube asks, is Bortland getting arrested soon or is he free until Melly's trial ends?
Currently he's on house arrest and he's free. And he's been free since, I would say, since 2019.
And Bryson, we have another question now from YouTube. Liz Herrera asks, do you know if Melly and his ex-girlfriend's mom are on good terms?
I wouldn't say that Melly and the ex-girlfriend's mom are on good terms, but we definitely just saw his younger brother and the mother of his ex-girlfriend walk out the courtroom and hug and embrace each other.
All right, and Afi, there's a question for you here. Letitia from YouTube asks, does the state's evidence and witnesses connect the defendant to the case so far?
Yes, he's definitely connected to the case. I think the video beginning with him leaving the studio, was it at 4:02 a.m. or something around that time? So that's definitely the start of the connection. And then you have to look at the drive that he took. We do know that the red car went into the community where they were all living or staying while they were reporting. And then Cortland went on to the hospital. So, and then he's, of course, also been connected with the mother's testimony. And I believe she said, or is expected to go into detail, where he calls her daughter and says that he believes that, Juvie and Sack have been shot, and it was a drive-by. So he's definitely connected. He's in there. Without a doubt. I think that they just need to, for me, I have not seen them put the gun in his hand.
All right, we
That's
have under
what I need to see.
a minute here, Afi. I just want to ask you 20 seconds, another question from YouTube. What happens if there's a hung jury?
If there's a hung jury, the prosecutors are going to have to regroup, and they will have an opportunity to decide whether or not they want to retry the case.
All right. Well, thank you for answering those questions. Great insight, great analysis as always. We're going to take another quick break here on Law and Crime, but when we come back, we are going to take more of your questions and we're going to dissect more of this case involving YNW Melly and his double murder trial. It is day 4 of this case. They are currently on a lunch break right now in Florida. More to come here on Law and Crime. We will be right back. Hi everyone, I'm Michelle Yu and you're watching our special YNW Melly double murder trial Q&A session here on Law and Crime. In case you're just joining us, our focus is on Broward County, Florida for the trial of Jamel Demmons, also known as YNW Melly. The South Florida rapper is charged with 2 counts of first-degree murder for the 2018 shooting deaths of Anthony Williams, also known as YNW Sack Chaser, and Christopher Thomas Jr., also known as YNW Juvie. We are currently taking your questions on air, so please submit your questions on Twitter, Facebook, YouTube, Instagram, TikTok, you know it. We'll do our best to get as many questions answered as possible. Our legal panel continues to be here with us to break everything down. So Brian Buckmeyer, I'm going to ask you here, YKX2 from YouTube has a question. Question is, why is Melly getting the death penalty and Bortland is getting life in this?
Great question. I have to look at this into this myself. The main reason I think is because they think he's a shooter. I think they looked at the trajectory of the bullets. They look at the video from the recording studio of when people went in to the vehicle, and they say, hey, bullets come from here. YNW must have sat here. Therefore, this is the shooter. They should get the death penalty, as opposed to Henry, who goes up and lies to the police, according to the forensics and the police, to say there was a drive-by. They're saying he's not the shooter, YNW Melly is the shooter, and that's the difference there. That's about all I got. I think they could have, and also Henry's charged with accessory after the fact. They could have gone the death penalty for both, but I think those are the facts that lead to their decision.
Great clarification there. All right, thank you, Brian. Bryson, this one is for you. Question from YouTube here. Amanda Johnson asks, why did the defense suggest Melly cover up his tattoo of the victim's mother's name, according to Juvie's father?
They believe that it would be a perception for the jury, and they didn't want to have any. They wanted to leave things at unbelievable, or they wanted to leave things that are just that could cause any type of sway in the jury to go to being guilty or versus being not guilty, and they just didn't want any perceptions, they didn't want any cracks, anything. So.
Yeah, the turtleneck and the tattoo has been a big topic of conversation. A lot of viewers wondering why. All right, Afi, we have a question for you here. Papa Doc has a question from YouTube. Do you think the evidence is enough for a guilty plea?
A guilty verdict? At this point, no, but we've got a long way to go. But at this point, I don't think that the prosecution has done enough yet. And I don't think that, I don't know that if they're even offering a plea, and if they were, I don't think that the defense would advise Melly to take the plea. Who knows what the deal is, but something the prosecution, I think they need to do is they need to show the jury. They have not shown me that this is, especially asking for the death penalty, knowing that it's on the table, you need to show me that this is some sort of premeditated, cold-blooded murder, and I don't think that they've done that yet, but we've got time.
All right, Afi, I have another one for you. Amanda Johnson asks, why was Cortland Henry allowed bond but not Melly for the same charges?
There are a lot of reasons that a judge or court may allow bond versus one defendant versus another. So a lot of times they look into the severity of the charge. They'll look into your criminal history. It just depends on what arguments their attorneys put forth. But there are a lot of variables that go into a bond number.
All right, Brian, we have one for you here from Lily from YouTube. Why is the driver not being questioned as he was a witness?
Could be a number of reasons. What people also often say when it comes to witnesses is you get what you get. You can't pick the witness who sees the most amount of information and is just amazing in front of a jury. So when I see a witness like this, and Lily, I think you hit the nail on the head, when I see a witness not testifying who has such great information, I start to think, okay, are they not going to testify in a way that the prosecution wants? Do they not see the information as the prosecution hopes and would be able to lay out to the jury? Are they not going to carry themselves very well in front of the jury, either through mannerisms, the way they articulate themselves, or do they have some good information, but a lot of bad information that they don't want to present. The major question for me now is, if the prosecution doesn't call them, will the defense? Because if the defense does, and they have good information for the defense, wow, that breaks apart the prosecution's case in a major way.
All right, moving on here. Bryson, we have one for you. Jake Holiday from YouTube asks, what do you think the verdict will be with the evidence been shown right now and the witness has been on the stand?
I believe the verdict right now is still up in the air. It's really a chess game right now between the defense and the prosecution. It's only been 4 days. We got a long way to go, a lot more testimony to hear. So it's only a matter of time right now. It's just up in the air. Both sides are delivering very strong points. The defense more than the prosecution right now. But like I said, it's all a chess game.
Yeah, there's still a lot to hear in that courtroom for a decision to be made. Afi, we have a question now from Tanya Julia. She asks, if Melly was in the car with the victims, how do you think he killed them, and to say that it was a drive-by shooting?
I cannot speculate as to how he may have killed them. But I do want to say there are two people who are living who were in that car. Who know what happened. And back to another point, if the defense does not call the driver, what does that say? A lot of times the audience, which is you guys, as well as the jury, they want somebody to testify. They want live testimony from somebody who was there. So of course, we may not understand it, but the defense, the defendant does not have to testify. He has the right not to testify, but there is somebody who was alive who could testify. So I think the jurors and the audience is going to say, hey, why isn't the driver there? That's a person who could just lend so much credibility and eyewitness testimony as to what happened. So I think, that's going to be something that's just going to percolate until we just get answers.
All right, Brian Buckmeyer, we're back to you now. Anthony Bongiorno has a question. He asks, how did the prosecutor get approval to file these charges? They have little to no proof?
Well, Mr. Bongiorno, great name, by the way. When we're talking about arresting someone, filing charges, getting an indictment, and then even getting a conviction, those are different levels or standards of proof. To arrest someone, just probable cause, more that they did or did not commit a crime. To get an indictment, it's preponderance of evidence, or another way of saying more than likely, or it's just 51% chance that they committed the crimes. I think even though what we're seeing now, and I think what you're hinting at, and please correct me if I'm wrong, is that the evidence so far seems too weak for a conviction. It might have been strong enough for an arrest and an indictment, but this is why we have trials. This is why we have a jury of your peers. This is why we have one of the highest standards in our legal system for a conviction, because if it doesn't reach that limit, we don't take people's lives, we don't take their liberty, we don't take their property. And I think that's the struggle here. The prosecution had this case in the bag, it appears, at a lower level in standard, and we're still waiting to see the other evidence they present, but it doesn't seem to get anywhere close to beyond a reasonable doubt at this point in time. So easy to start a case, maybe not so much to finish it.
All right, well, our viewers are getting into this. Tanya Julia back with another question. Afi, I'm going to let you take this one. If Melly was in the car with the victims, how do you think he killed them? And to say that it was a drive-by shooting?
So I think the prosecution is saying two separate things. The prosecution is saying that Cortland and Melly are shaping up an argument that it was a drive-by shooting. But they've also indicated that the death shots, if you will, or those that caused the death of Sack and Juvie were coming from inside the vehicle. So it couldn't have been a drive-by shooting, and it was staged. So I think that's the prosecution's position. And the defense doesn't have to prove what happened. So I don't think that they really have a position other than they believe what their client is saying, which is that there was a drive-by shooting.
All right, we now have a question from TikTok. Bryson, I'm going to let you take this one. The question is, how many days do you think this trial lasts?
We're a bit unsure at the moment. They asked the prosecution yesterday, the judge asked the prosecution yesterday the expectancy of this trial, and they said July 10th, and then the defense said July 19th, and then obviously today a sheriff mentioned to a legal intern that the trial could go all the way until August. So we're up in the air as far as how long this trial will last.
All right, Brian Buckmeyer, we have Mikey from Instagram who asks, how can they kill a man without having a murder weapon?
Pretty easy. We've seen a lot of cases like this. Oftentimes, it's, think of Theodore Edgecombe. We had that case, the Law and Crime covered, where he shot and killed an attorney, I think his last name is Clearman, and fled the state and dashed the gun outside of a car window. This could be a situation where in the time that Henry went to the police, I don't know what could be argued. Maybe Melly took the gun with him and threw it somewhere. Maybe after the shooting inside, they tossed it somewhere. We've had no body murder cases. Like no actual body there. We've had no weapon murder cases as well. And so in that situation, it's about circumstantial evidence that connects. Clearly, gunshot wounds went through a person's body, so a gun must have existed along with the shell casing and holes to prove it. But not having the gun, not having the forensic that attaches to it, makes the prosecution's case weaker, but doesn't eliminate it altogether.
All right, Bryson, I have one question here for you from M. Pilo. He's asking, is Melly going to get a chance to speak? Do you think he will testify?
It's too early to say right now. It's a good chance that he will. A lot of cases usually have the person accused testify last. So we're up in the air right now as far as there has been no documentation that shows that YNW Melly will testify for his double murder trial at the moment.
All right, well, I want to thank the viewers for all the questions you guys are putting in. And a lot of our chatters on YouTube have commented saying, free Melly, free Melly. And I want to go by one here around the panel and ask each of you, how much do you think social media plays into this trial? I mean, the South Florida rapper was a rising star. Brian, I'm going to start with you.
I think it indirectly affects the trial. And I say that as a defense attorney who's probably thinking, what is the defense and the prosecution themselves thinking about this case? We here at Law and Crime know that even the attorneys in these cases will be following our network to see what the court of public opinion is thinking, because oftentimes it's not too far from what the jury would be saying. And so seeing what people are saying online, the arguments back and forth, and maybe even some of our guests and hosts and what they're talking about can let a attorney, whether prosecutor or defense, say, hey, I might be winning today, losing the day before, but it seems like I'm in a good place because the court of public opinion agrees with what I'm doing. But directly to the case, it has no bearing.
Afi, what are your thoughts?
I completely agree. If I were in the courtroom, I would have someone monitoring the chatter, and I would want to see what they're asking. I would want to see the immediate feedback, because it's like a perfect pre-test jury. And it's just like somebody just asked, will Melly testify? You know your jurors want to see him testify. So it's like immediate perfect feedback. You know, what am I doing as an attorney that's either turning off the jury or inviting the jury? So it's absolutely a good tool, perfect for me.
Bryson, what do you think?
Well, as the person doing the live tweeting in the courtroom at the moment, I can honestly tell you, based on what Brian said, yeah, you're right. The court of public opinion really has no sway when it's 15 jurors that decide your fate. So really, I mean, Melly is getting, as I look at the tweets, Melly is getting love and praise, free Melly hashtags from all over the world, from France, Brazil, Netherlands, even and along with the United States. But as I can say, it's all up to the 15 people sitting in that jury box.
Bryson, a lot of our viewers want to know what we aren't seeing in that courtroom. What else can you tell us about who is inside the courtroom today? I mean, we saw Felicia Holmes take the stand today. Do you see her daughter in court?
Her daughter is scheduled to testify. She was supposed to testify before Holmes, but I guess something got mixed up, so they had Holmes go first. And then just everything going on in the courtroom, Felicia Holmes' testimony was really important for the victim's family. They were really anxious and excited to hear from her or have her take the stand. But we have to wait until we go back from lunch to see as she continues to be on the stand, or on trial, or taking the stand at that. And so we just have to wait and see.
Also, someone was escorted outside of the courtroom yesterday. What can you tell us about that, Bryson?
Yeah, they had a gentleman escorted outside that looked at Melly and gave him, or put 2 pounds of, or pounded his fist 2 times on his chest and called out another man to come outside. As afterwards, sheriffs came out to say they needed help outside, but there was no other word of any commotion or anything of that sort that went on. So it was just Melly afterwards at the end of the trial, where obviously we could show on Law and Crime that he was displeased, he was angered, and he really showed a different side of himself that he was normally to his calm, cool, charismatic self.
Bryson, I'm curious myself to see what the jury's reaction was when Melly blew that kiss, which the victim's family said was disrespectful. Did they see that? How did they react to that?
It wasn't really him blowing a kiss. It was him reciting a prayer that ended with blowing a kiss. It's more like he was saying the prayer and then he blew it out into the world. But I don't think the jury was even aware of what was going on or aware of what happened. Now, the victim's family were displeased, but they were completely displeased with the fact that he's as charismatic and trying to be as charming as he can be to the rest of the courtroom. Having celebrities show up on his behalf and whatnot doesn't sit well with them at all. Just him showing the lack of remorse doesn't sit well with them at all, and him just not really caring about the fact that he is on trial with the state seeking the death penalty it's upsetting to them.
Bryson, anything you're expecting to happen this afternoon and as the rest of the trial continues?
I think a lot of eyes will be on Kevin Lyles, who is the label owner of the record label that YNW Melly signed with in 2018, right before he surrendered himself to authorities. And they're going to be looking at him and his demeanor and what he'll be doing and how supportive he will be with Melly. As we walked out the courtroom, it said he told Jamie King that it warmed his heart to see Melly in the courtroom, and Jamie King also replied and said that for Melly, it warmed his heart to see him come and support him. So I think a lot of eyes will be on Lyles, as well as the victim's family, who visibly show their upset, visibly show their anger, and consistently stare at Melly instead of paying attention to the trial at hand.
Bryson, thank you so much for those courtroom tidbits. We look forward to hearing more from you later. We have a couple of more questions before we take another break here. Brian, I'm going to have you take this one. King Punky has a question. He asked, do you think Felicia Holmes' memory loss behind her statement will work in Jamel Demon's favor?
Well, King, I'll put it this way: it's definitely not gonna hurt him. And this is the way I think about it. You might not win every witness and from what they say as a defense attorney or as a defendant, but so long as it's not hurting you, in of itself, that's a win. I don't see them being able to take her testimony and use it to their advantage. I don't think it's really even going to come up on the defense's summation. But the fact that they put a witness on the stand that didn't really hurt the defendant, Mr. Demons, I think that can be pointed to as this is a botched investigation. Why did they bring this case? Why did they bring this witness? This is a waste of your time. This is a waste of my time. Go back there, come back in 5 minutes, and let's get a not guilty verdict, and let's get out of here. So in that regard, I think it does help.
All right, we have one more question before we take another break here. Afi, I'm going to let you handle this one. Alicia Richardson asked, do you think there's enough evidence for a death penalty?
Thanks, Alicia. I think that at this point, no. And as I said earlier, you've got to show me that there was some sort of, for me, I would need to see some sort of conspiracy, some sort of cold-blooded, premeditated murder, and I don't think that the prosecution has done that yet. I do think motive is something that I'd want to see, and that's why I think it's interesting that Mr. Lyles is going to testify, because I had read and heard that a motive might have been money, and I do wonder what he was doing with the label, what kind of deal were they working out, how was money involved and was there's some type of confusion or disagreements between the artists with respect to dealing with the label and the money and the licensing of the name. So, but thus far, I do not think that they have proven or shown me any motive, and I don't think that there's been any proof to me of cold-blooded, premeditated murder, and they still have not put the gun in his hand for me.
Yeah, there are still a lot of questions that everyone has, and hopefully we're going to get more answers as this trial progresses. I do want to thank all of you for joining us for a very special Q&A on this Melly double murder trial. We hope to see you again soon. We're going to have to take a quick break here on Law and Crime, but when we come back, we're going to check in on the courtroom and see what is happening next. Stay with us. We'll be right back. Thank you, everyone.
So the case law is clear that that is something the state can do under these circumstances. It's in the interest of justice rather than to have a witness who, for various reasons, is now professing a lack of memory to then be prohibited from introducing substantive evidence in the case.
So you're calling a witness that has testified that the witness doesn't recall, and you're suggesting that, I take it that she's feigning a lack of memory?
On some of them, I think it's accurate that she doesn't have a verbatim recollection of what was said. I think if she said that she did, that would be suspect. I think so. In terms of having a better memory back in 2018, 2 months after the incident or less than that, that is valid, and that she has said she was truthful with law enforcement at that time. So the state has met the admissibility threshold on that particular issue.
Thank you. And what says the defense?
Your Honor, I think the state undercuts its argument by admitting what she perceives to be the case, which is that concerning the gravamen of what she's trying to introduce, she believes that the witness is feigning a lack of recollection. In other words, she is recanting. So this is not, and what's important to realize is this is not about determining whether we have a witness who is being honest or not. I think this rule contemplates a witness who may be being dishonest by recanting. And the issue is not whether or not the witness is being dishonest, and in the interest of justice we want to put in what we believe to be a more honest statement. The question is whether or not you're putting up a witness to impeach them. Putting up a witness to introduce a statement previously made from which that witness has receded, or which that witness has recanted, which is what's going on here. And the rule is clear on that. Can't do it. It's hearsay, and it should not be permitted. Any issue with respect to whether or not the statement is sworn or not, I think sworn statements typically contemplate an adversary having the ability to test credibility at the time it's made. Furthermore, this witness, when asked by the state, did you give an honest statement to law enforcement back in 2018? She's like, I don't know that I did. She posited the possibility that she could have been lying then, which further undercuts the indicia of reliability. She also said she felt threatened then because she was speaking, given that she was advised that her, and I think advised in bad faith, that her daughter might be charged as an accessory after the fact, when there was no evidence to suggest that. And she said she was acting then under threat, and that she's not certain whether she was being honest then. So for the state now to say, hey, you know, she's having a failure of recollection, so we just want to read her prior statement into the record, is a pretext. And it runs in violation of the law in the state of Florida as explicitly outlined in the cases we cited and numerous other cases. So that's why we object.
Thank you. So, counsel, I've looked at a couple of cases that came across. First is 880 Southern Second 561 Pierce v. State, Supreme Court of Florida, and the second 993 Southern Second 1108 4th DCA case SL versus State. And in the first case, the Pierce case, that was an issue whereby during cross-examination of a state witness, defense counsel had asked whether or not the witness had previously told detectives and that he made a statement and expressed surprise at some piece of evidence. And the state, his response was he didn't recall, don't remember anything along those lines. And the end result was that the Supreme Court said in order to resolve this claim, and I'm reading from the 8th page of the opinion, it said in order to resolve this claim, we must examine the law relating to the admissibility of prior inconsistent statements. Prior inconsistent statements are not hearsay and can be admitted as substantive evidence. And quotes, if the declarant testifies at trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. Then it goes on and says this court has held that a statement given under oath during police investigation is not a statement given at an other proceeding and consequently is not admissible as substantive evidence. The second case I have is SL v. State, as I said, 993 Southern 2nd 1108, and that's a little more succinct. And at the second page of the opinion, it says, in order to resolve this appeal, we must determine whether the statement made by SL's mother to the deputy were admissible as substantive evidence. The Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. It goes on and says, interpreting this provision, the Florida Supreme Court recognized that a statement given during police investigation is not a statement given at an other proceeding, end quote. Doesn't appear to me that that statement is admissible as substantive evidence, counsel. So what the end result of all of this is, if you ask the witness denies remembering the statement and you want to read it to him, I don't see how a curative instruction telling a jury it's only for impeachment purposes and not as substantive evidence is going to resolve it. So my thought would be just to keep it out. So I sustain the objection.
So Your Honor, just so it's clear, it is not a prior inconsistent statement. So the line of case law that you cited would not be applicable. It's a past recollection recorded, which is a very specific subset. So I refer to Earhart on that specific issue, 9803 sub 5.
Excuse me one second. Could you get my earphone? I left it on my desk. sorry, Council, what section are you talking about?
9803.
In airport.
Yes, subsection 98035, which in the 2022 edition starts on page 1104. Citations. I provided a copy to defense and a copy for your honor. And the light is located at 116 7th 3rd, 270 Florida Supreme Court, 2013.
the case. Anything else you wish to share with me, counsel? How about from the defense? Anything else?
A commentary on the case that was just provided.
Yep.
I think the polite case, the very first head note, says that the admission of past recollection recorded under exception to the hearsay rule requires the witness to indicate that the statement was made at the time when the events were fresh in her mind, his or her mind.
That's done.
And also attest to the accuracy of the memorandum or record. The opposite of that was done.
Excuse me, and that's in the bottom as well. That you're reading the head note.
Yes.
I just highlighted the portion at the end. It says, we reject the 5th District's embrace of a totality of the circumstances test and affirm that in Florida, the admission of past recollection recorded under section 98.803 subsection 5 requires that the witness indicate that the statement was made at the time when the events were fresh in his or her mind, and also attest to the accuracy of the memorandum or record. Then it goes on in conclusion. In this case, a proper foundation for admission of the witness' statement of past recollection recorded was not established. As we've explained above, the hearsay statement was inadmissible because the witness did not vouch for its accuracy or correctness.
I have nothing further.
Counsel, my thought is this. If what I heard her say previously was that she couldn't vouch for its accuracy or something to that effect, if that's what she continues with, I'm not going to allow you to admit the evidence. All right? So, are you ready to proceed?
Yes.
All right, let's bring the jury. Are you ready as well? Defense, you ready as well? Yes. All right, bring the jury in. Yep. Bring the witness in, bring the jury in.
Grab the witness. While we wait, can you go sidebar briefly?
Yep.
entering.
Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of defendants, defendants, as counsel, and state attorneys. Ladies and gentlemen, jury, our witness, Bishop Holmes, remains on the stand. Ladies and gentlemen, I apologize for the delay. It's my fault. In any event, I think we're ready to proceed now. Ms. Holmes, I just remind you, you're under oath.
Yes, sir.
Thank you. Proceed, counsel.
Okay, so I'm going to talk a little bit about your deposition.
Yes.
Do you recall when you've been provided a copy of that deposition?
Yes, my lawyer got provided a copy.
When you, in that deposition, were you asked if your prior
Objection.
statement...
Improper impeachment.
I heard it over. You can ask your question, counsel.
Ms. Holmes, prior to that deposition starting, were you given your prior statement to review?
What you mean?
Were you?
I understand. The deposition that I did on December 22nd? Yes,
Yes.
it was given to my lawyer yesterday, right before, briefly to look at, yes.
So the deposition you have, that was
It was
provided
given
to
to my
your
lawyer
attorney?
yesterday, yes it was.
Okay. So, do you remember coming in for that deposition?
Yes, I do. I was in jail, put me in jail. Yes,
Correct.
I remember.
And so it's clear in terms of you don't want to be here.
You're making me be here. Yes, I have
Yes.
a house with a band on my leg. I'm a nurse. I can't even work properly. Yes.
Yes. You were under house arrest because you failed to comply with the subpoena?
No, you did not serve the
Excuse me,
subpoena.
sustain. Listen, how we're going to do this is you ask your questions, counsel, ma'am, listen to her question, answer her question.
Yes, I
All right?
am. Yes, sir.
Thank you.
Okay. So going back to the deposition.
Yes.
On December 14th of 2022.
Yes.
Do you remember coming to my office?
Yes, I do.
Okay. Do you remember being asked questions at that time?
Yes, I do.
Do you recall being given a copy of your prior statement of December 12th, 2018?
No, I don't remember that. I don't remember anything, but I'm pretty sure. I did.
Okay, so what I'm going to do is permission to approach her on it?
With what, counsel?
Her deposition.
Objection, Your Honor.
I have to give her an opportunity to.
I saw my.
Excuse me. There's no question pending review. All right, you can proceed, counsel.
Okay. So, counsel, I'm showing her page 10, line 10 through 17. Okay, so just read them silently to yourself. So back on December 14th of 2022, were you asked if you need to make any corrections or deletions to the statement of December of 2018?
That's what the deposition said, judicially.
And did you indicate that there was no corrections or deletions in those statements?
I don't remember, but that's what's on the deposition.
Okay. So, December of 2022, you said that this was a correct statement.
Objection.
Sustained.
So, Ms. Holmes, is the December 2018 statement correct and honest?
Objection. Ask and answer.
Excuse me. You have to let, I understand you're trying to answer the question, Ms. Holmes, but when they raise an objection, you have to let me answer the objection first.
Yes,
all
sir.
right? Objection notice overruled. Question is the statement, repeat your question.
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
In December of 2022,
Yes, ma'am.
did you state that it was an honest and correct statement?
That's what you put in the deposition. I don't remember saying it, so I can't remember verbatim what happened that day. I remember some parts of this deposition, but not all.
Okay, is there anything that you need to refresh your recollection to determine whether or not I'm being truthful and accurate as to what the question was in your answer?
I don't know to say that.
Okay.
Is that a question?
I've asked if there's anything that was...
Excuse me, one at a time. All right? Just one at a time. Let her finish her answer before you ask the next question.
So, Ms. Holmes, is there anything that would help refresh your recollections?
I don't think so. I don't know.
Would the audio of the statement of December 2018 help you?
Objection.
What's the objection?
It's irrelevant. She testified 3 times.
Excuse me, thank you. Not us to this, go ahead, overrule.
I don't know. I don't.
So, Ms. Holmes, with regards to the events of October 26th of 2018.
Yes, ma'am.
Did you travel down here to Broward County?
Yes, I did.
Who did you come with?
My daughter Mariah.
Okay, where did you go?
We went to one of Janelle's friend's house.
And whose house was that?
Frida.
And now approaching what's been previously shown to defense counsel and marked as states N for identification purposes only. Ms. Holmes, do you recognize the 2 individuals in that photograph?
Yes, I do.
How do you recognize them?
I know Frida from being on Instagram from rapping. He's a rapper.
Okay. Any other individual in that photograph?
My daughter's boyfriend.
Okay.
I'm sorry, I apologize, I didn't hear that.
I'm sorry.
I didn't hear your answer. Could you
Which
repeat?
one? Do I recognize?
Thank you.
I do recognize Frida from Instagram for being a rapper, and I recognize Janelle from dating my daughter.
Your Honor, at this time, state we request to move states N in as the next number of exhibit.
Any objection?
Relevance.
Overruled, it'll be admitted.
States N, be marked states 62.
This is the photo that you can see on your screen that you just identified? Okay. So when you said Frito, is this the individual's house you went to?
Yeah.
Okay. Ms. Holmes, how much money has the defendant's manager given you since the October of 2018?
Objection. Relevance.
Why don't you come sidewalk?
how much money have you gotten from the defendant development manager?
None.
And with regards to that specific statement? Ms. Holmes, you have formerly had a credit union account?
Yes, I do launch credit union.
Okay. And at Launch Credit Union, you banked there for a number of years?
Many years.
The credit union that you've been at, it's been your account, and I won't put your account number on the record for that reason.
Can I object to this line of questioning based on the court's ruling?
Objection, no, so proceed.
So your testimony is that you have never been given money whatsoever?
I've never been given money for personal use.
Okay. So the question is, how much money have you been given by the defendants?
For vacation for all of us, for him, his wife, and me to pay for it. As far as he gave me $5,000 for Airbnb, which I gave him $1,000 to deposit that.
So he did give you money?
Not for personal use.
Okay.
Excuse me, can we clarify who he is, Jameson Francois?
Objection, no, just clarify, counsel.
Sure. So it's clear, who is Jameson Francois?
He's Melly's manager.
And you mentioned his wife as well. Who's his wife?
I used to go by AA.
So AA and his wife.
We were all good friends.
Okay. So I'm going to go through now what's been previously shown to defense counsel and marked as states triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming into court today?
Yes, I did.
Okay. And in terms of the individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I do not.
Okay. Going forward through the contents of that particular item, do you recognize a conversation about a snake?
No, I do not. I know they had a snake. I don't recognize this conversation.
Okay. With regards to the conversation about the snake that you do remember, what do you remember about the snake?
That they had a snake.
What happened to it?
Objection. Relevance.
Sustained.
Aaron, may we approach that?
Sure.
Ms. Holmes, I want to ask you a question as to what was your daughter's phone number back in October of 2018?
I have no idea, I don't know.
Is there anything that would refresh your recollection as to what her phone number was?
No, because I don't remember mine.
You don't even remember your own?
Yeah, no, I don't.
In terms of, did you review your statement of December 12th of 2018? Did you review that statement prior to testifying today?
Yes, I did.
And in that statement, were you asked, what is your daughter's phone number?
Objection.
Overruled. I don't remember.
If I were to show you the statement, would that help refresh your recollection as to whether or not you were asked that question?
I don't think you would, no. But you can show it to me.
You have permission to approach?
Yes, ma'am.
Okay. 3 of 8. If you could just read silently to your son. Okay, looking at that, does that refresh your recollection as to what your daughter's phone number was?
I still don't recognize the number. It doesn't for me, but I don't know if that's her number. I don't recognize the number.
Okay, so you don't recognize the number?
Yeah, I got 3 daughters, so I don't know.
Understood on that one. So, do I have permission to treat the witness as hostile?
Objection. What's your sidebar, please? Some time with the attorneys, please, as you go to jury, do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, and certainly no research. There's leaving no paper on your chair. Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant. Witnesses on stand. Ms. Holmes, my understanding from counsel's side is that you have an attorney deal with you. Is that right?
Yes, I do.
No, I was told to bring him in here.
It might be a good time for you to talk to him. So, you want to speak to your attorney? Any objection to that? by the way?
Yes,
What's
yes,
the
Your Honor.
objection?
The witness is on the stand, and for the state to suggest to a witness who's already been sworn and is in the middle of testimony that she goes and talks to her lawyer, it's type of intimidation and coercion. I think the rules have this. So we do object to that. It's intimidation.
Well, let me ask you this. Is it something you think you need to talk to your lawyer about?
I'll talk to her. I don't think I need to, but I don't know what the problem is. I'm answering her question like she wants. I'm not sure what's going on.
Well, so my question to you is, do you want to talk to your lawyer?
Yes, I will talk to her.
All right, so we're going to be in recess. You talk to your lawyer, and you go ahead. You can step outside, all right?
Okay.
And I'm going to continue with the argument here with the attorneys. So I guess this is the concern I had. You're asking me to declare her a hostile witness. So here's the mission is, I don't know if what's your position on it. She's at, that would allow her to ask these legal questions as she suggested sidebar. The problem with any of the questions, though, I don't want you to be asking specific questions that things that she said previously she doesn't remember, and that you're just going to go ahead and put testimony before the jury. I mean, that's, it's not the attorney's questions that are in evidence. I mean, if she doesn't acknowledge it, or even after asking leading questions, she's basically saying, she doesn't know, or that's the end of it. I mean, you can't go much further than that. You can't put in evidence. Didn't you say X, Y, and Z? The police officer, she's not acknowledging she said it. I can't see, how you do that. You can't.
So, Your Honor, I think I can ask the questions because
What question?
In terms of, did you provide this phone number as the number for your daughter? Did you provide this number for the phone number regarding Mr. Dennis? Did you provide this information?
What information?
Whatever the particular statement may be that we're at that point in the questioning. For example, did you provide the phone and say that previously that you talked on FaceTime with the defendant? That you talked to him on the FaceTime on the 772-713-9807 phone number? So judges, in terms of if I'm going to then impeach her with some other outside statement or some other prior consistent statement that she has made at some other proceeding at that point, that's the concern as to her perjuring herself on that. So I think that's why it's important that she be allowed to speak to her attorney on that issue. And in terms of the prior statement on that, I still maintain that she has endorsed its authenticity and accuracy. Your Honor was provided with a copy of that deposition that the state referenced when we were talking about, and she indicated she was honest and truthful in that deposition, and she then endorsed the prior statement. So the prior statement should be allowed in on that, and if there's no concern as to any improper or anything on the jurors, because they will be instructed, as they always are, that no statements by the attorneys are evidence.
Yes, please. Your Honor, first of all, the state is now conflating issues. What we objected to and alerted the court to because we knew that this debacle was going to take place, I think it is evident that, yes, it appears as though the witness is not a major fan of the state. That's true. The state knew that going in. This is no surprise. These cases use the very language, surprise. In other words, what the state intended to do under a ruse at 90.803 section 5 ruse is put on the witness to impeach that witness for that sole purpose of impeaching the witness, to introduce an out-of-court statement that is inadmissible because the state understood that she recanted. The state, under the pretext, oh, we don't know that she's hostile, we just think her recollection is failing, and we believe under 90.803 subsection 5, we can just read her statement in. Unfortunately for the state, the Supreme Court has made it extremely clear that that witness has to vouch for the accuracy of the statement at the time it was made. And the Supreme Court also said in that context that in the context of an 803.5 exception, the contents of the record substitutes for the witness's testimony. This means that the reliability of the assertions rests upon the veracity of a witness who is present and testifying. The state is calling into question her veracity and calling her pretty much a liar, saying that she's feigning recollection and now attempting to essentially introduce a report of a police statement into evidence by the state testifying, asking the court to let the jury know that all this stuff that we're about to say, upon which we want to rest our case, is, don't take it from me because I'm just a lawyer saying it, but then there's no point in saying it because there's no way to get it through this witness. She can't put her on to impeach, which is exactly what she's trying to do. The 803.5 is a ruse, and that's not working out, and now she's doubling back to the original, which is let me call her hostile so that I can lead, and instead of eliciting the testimony from her, I'm going to read it out of this report and say, didn't you say that? So what happens is we're going to now be in a situation where she's asking the state to tell the jury, hey, what the lawyers say is not evidence. So it doesn't matter that this witness is going to say, I do not remember that number that you just read to me. That you just let me see. I told you I don't remember it. So I now now the state wants to come back to the podium and blurt that number out. She just said she doesn't recall it. So what's the point of saying it other than to introduce it into the record through the state attorney's lips? So rules don't allow her to do what she's trying to do.
Thank you.
So you're in further support of treating the witness as a hostile witness. This has previously been provided to defense, but this is the Instagram production for Miss Felicia Holmes that I'm showing the court now that she has previously identified as her specific Instagram, and that it is saying the promises that were made to us by Y&W for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company said. Now look, we can't go home. We're spending all my money I worked for and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitch Bitch. So Judge, it's very clear from this record that my intention and what the witness has represented to me in all shapes and forms that she was going to be honest and truthful. So to say that it's improper for calling her just for the purposes of impeachment is incorrect. So to continue on in that same Instagram production, and this is in June of 2022, Felicia Holmes is saying, they made me quit. Told me that they would take care of us until trial was over. But guess what? Lies as usual. I was making $9,000 weekly. I didn't need shit from them, but everyone begging and pleading. Now they all ghost. I got something for Track though. He lied to me and my child for the last time. Again, saying you're going to air him out to the prosecutor. So Judge, in terms of, so that's in defense of the representation of counsel that she's just being called for impeachment. It's also clear that this witness has received multiple benefits from the defendant based on her own statements there, that she has endorsed that that was her Instagram on that.
So, counsel, there's a couple things going on here. Number one is you indicated that it was the testimony was going to be admitted because it was in essence I forget the statute number.
9803 sub 5, it's a past recollection reported.
Past recollection recorded, and you
Correct.
gave me the polite case.
Yes.
And that indicates that you have to have a proper foundation, but it has to be not only there's a proper foundation, but it has to, the hearsay statement was inadmissible in that case because the witness did not vouch for its accuracy or correctness, which is what we have here. The witness isn't vouching for the correctness or accuracy of the statement. So it doesn't meet that criteria. On the other issue about impeachment, you know, this is not what she said. She's, you know, she said gave me a different answer. What I tried to read before was something from a couple of cases, and again, the synopsis of at the end of it. This is I'm just reading again from the SL, a child case, v. State 993 Southern 2nd 1108. It just says the Florida Rules of Evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at the trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. It goes on and says, interpreting this position, the Supreme Court of Florida recognized that a statement given during a police investigation is not a statement given at an other proceeding. So, then if you agree, I don't know where we're going with this, counsel, respectfully. It seems to me under either scenario, that statement doesn't connect. Now, I do have a message from Mr. Bears, B-E-R-E-S. He says he's Ms. Holmes' attorney. He would like to speak with me. I don't know what he wants to talk with me about. Candidly, I'm assuming it's this testimony. But anything he can say right here in open court. I don't have an issue with that.
That's fine, Your Honor. I really question the purpose in advising my client, Ms. Holmes, to consult me for a lawyer. I take that as an implicit threat to Ms. Holmes. We have an agreement that she comes in here today to testify. She's done that. She's honored her agreement. And, you know, she's answered all the questions put to her. She may not be answering the questions to the satisfaction of the state, but she has fulfilled her agreement. And now Ms. Holmes is again placed in fear. And that's all I have to say.
Thank you. All right, let's, anybody need a restroom break or anything? You ready to go?
Yes, sir.
Pardon me?
Judge, I think someone on the fence.
I need to go to.
Sure. We'll take a short recess.
just like for the court to order this witness off the stand. I think the state has demonstrated that the only purpose for which they want that witness there is for the improper purpose, and they're compounding the prejudice by having her remain there. I think that the state has something that's admissible that they can prop to this court, that witness needs, testimony needs to be concluded.
Thank you. They were here.
Judge, the state's not. There's additional information and things that's open to being talked about.
Thank you. So this is my thought, counsel. I don't have a problem declaring the witness to be hostile to the state and allowing you to ask leading questions. I'm okay with that. I think that's been established. She's wearing an ankle monitor that was put on there by the state. I guess pursuant to this hearing where she was, I think you said she was Virgin Islands?
Yes, sir.
Regardless, so I've allowed that. The problem I don't want to happen, so we're clear, is I don't want you to regurgitate things that are in her statement that she's not, that doesn't comply with either of the two rules we've been going over. So I don't want you to be saying, well, didn't you say to, the police officer, Mr. Moretti, or whatever, the officer's name is Detective Moretti, that you saw them on FaceTime or whatever it was, that they were on that date when the incident in question happened, and Mr. Demons told you X, Y, and Z. All right? The witness hasn't subscribed that that statement was accurate, so it's not getting in under recorded recollection, and it's not getting in as impeachment because it's not. It's a police investigation, not a deposition testimony or something along those lines. So it doesn't get in the way I read the rule under either of those two sections.
So
I don't want you to get in the back door, which you can't get in the front door.
No, just to make it clear, is Your Honor holding or stating that a police report cannot be used to impeach someone?
No, I didn't say that. What I said was the statements in the police report, right? You can't just have that, read that back to her. Didn't you say this to the police officer? I don't want that being done. I don't think that's appropriate. She says she doesn't remember the statement, doesn't know it's accurate. She didn't rely on its accuracy. And
Understood. And I just want to make sure it's also clear, under 9803 sub 5, the past recollection reported, there's no requirement in any of the case law or statute that the statement be sworn on that. If you look at that, because if there's other statements this witness has made that she may endorse as being truthful and accurate, and I'll have to ask her on that, then those are possibility of other ones that could be put in.
Your Honor, among the statements that we would like the court to forbid the state from asking in a leading fashion are the phone numbers or anything that she said to the officer on the day in question. What's the date that statement was made?
December 12th, 2018.
Nothing from that statement should be.
she'll ask whatever question she thinks is appropriate. You make your objections, but I don't think it's appropriate to be asking, didn't you say this, X, Y, and Z. I don't think that's appropriate because she's not subscribing that this is what she, that statement is truthful, so I don't want you to just be regurgitating the statement and asking her that. I don't want that done, and I don't want you to do, anyway, we'll see where it goes.
Yeah, just one thing, Your Honor, I'm sorry to belabor the point, but I want to make sure that the state doesn't confuse the court's ruling to be one of form over substance, and instead of saying, didn't you say this, say, isn't it true that, or anything where the contents of that report are uttered out of her mouth that she knows this witness had not adopted, and she's going to get a no, and she's just putting it into the record. It's improper. And
Hopefully I made myself clear, but that's why she's going to be able to Council's going to be able to ask whatever questions she deems appropriate. You make the appropriate objection if you think it's objectionable. I'm just going to rule. We're going to go forward like that. I don't know what you intend to ask council. I just don't want it, the contents of that statement, regurgitation of that in some form of leading questions, all right? Bring the jury in. Let's get the witness back in. Thank you.
I'm sorry.
Jury entering.
Ladies and gentlemen, thank you. Please be seated. Let everyone once again reflect the presence for a jury. This is Martin Jones, City Council, the Associated Attorneys, ladies and gentlemen, the jury, and our witnesses home for being on stand. Apologize for the delay. Council, ready to proceed?
Yes, Honor.
Please.
Okay, Ms. Holmes, when we left off, we were talking about a pet snake.
Yes.
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure probably, I'm not sure, it's not here, but I'm pretty sure.
Okay. Do you remember the name of that pet snake?
No, I don't.
And in terms of the owners of that snake, do you remember who owned it?
I just know it was, I know who the owner was. It was in the house with Mariah lived.
Okay. Where did Mariah live at that time?
She lived in BMR.
And do you know the address?
No, I don't.
Who did she live with?
She lived with a boyfriend, but you know.
Are you telling the ladies and gentlemen of this jury that you don't remember your phone number in
I'm
October
telling you guys,
2018?
I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of this jury that you don't remember your daughter's phone number?
No, I do not remember my daughter's phone number.
And there's nothing that would refresh your memory or recollection whatsoever?
Objection, asked and answered.
Overruled.
That was 4 years ago. I've had so much trauma in my life since then.
Of course. So, is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drug fight?
No, because they said his friends had been in a drug fight.
Okay. And you were worried about him because he was hiding in some bushes?
Objection.
I don't remember him in the bushes.
Okay. What do you remember?
I sustain the objection.
What do you remember?
I just remember him saying for us to come get him.
When you made contact with him later that same day at Frito's house,
Yeah.
is it fair to say he had no blood on him?
No, he didn't have any blood.
And is it fair to say that he left Frito's house and went up to a video shoot that afternoon evening?
Yes, he did.
Did you go to that video shoot?
No, I didn't.
Did Mariah live with Mr. Dennis after the homicide for a period of time?
Yes, she did.
Did she live in a condo in Miami with him?
Yes, she did.
Okay. Have you made other statements about the events of October 26th of 2018?
I don't remember making any other statements.
Do you recall a Instagram conversation with the co-defendant Cortland Henry?
I don't remember it.
Okay, if I may approach, I'll see if this refreshes your recollection as to that conversation. It's 3 pages.
Is that from Mark, Counsel?
Not yet, Your Honor.
I don't remember it. I don't remember it.
You don't have any recollection of that?
I don't remember it.
Is that your Instagram, LaneQueen258?
Yes, it is.
Okay, and the conversation that you don't recall on that whatsoever?
Yeah, I don't remember it.
Okay. Is your testimony here today that you lied in those statements?
That I lied in my statements.
The allegations that you made to Mr. Henry?
I don't remember making those allegations, so I don't.
Do you remember sending screenshots of those allegations to a detective?
I remember sending a detective something stating that I didn't threaten Portland.
No.
That's I remember that.
You remember sending screenshots of conversations?
I remember telling him that I did, because he reached out to me, asked me that I threatened to kill Portland, and I said no, I did not threaten Portland.
Okay.
I remember that.
Was there any threats made to you by the defendant?
No, not at all.
In terms of your daughter, Mariah, where is she?
I don't know.
After this incident, did she live with the family of the defendant?
She's always lived down there. Before this incident, she always lived there.
And it's your testimony to the ladies and gentlemen of the jury here today that you saw Jamel Demons October 26th of 2018.
Yeah, I saw him.
That you spoke with him and heard him on the FaceTime conversation.
I did speak to him, yes.
And it's your testimony that he indicated that it was some sort of shooting that occurred.
Yes, I did, yes.
Okay, and it's your testimony that you saw him on your daughter's cell phone as a video call.
I saw him.
Is it your testimony today that after that you called Jamie King?
Yes, I did call Jamie.
And in terms of the conversation with Jamie King, that occurred immediately after the FaceTime?
Not probably immediately, but sometime after. I'm not quite sure the time. I don't remember what time it was.
Okay. And it's your testimony to the ladies and gentlemen of the jury today that you were dishonest in your first statement?
I don't remember my first statement.
Okay. Is it your testimony to the ladies and gentlemen of the jury that you would lie?
I don't remember my first statement. I have no reason to lie to you.
Yes or no? Did you lie to police?
I did not lie to you, no.
Yes or no, did you lie to police?
I didn't lie to you. I don't remember my first statement. You're trying to make me say I remember my first statement. I didn't. For me to say no, I didn't lie would mean I remember my first statement. I don't remember it, so I don't remember.
Well, if you need more time to look it over, I have a copy of it here.
I've looked it over and I still don't remember it.
Okay. Well,
I did it over 100 times. I don't remember.
Well, if you'd be so kind as to do it one more time.
Yeah, sure.
You can say that to this jury that this is not truthful.
Yes.
Please.
Objection asked and answered 5 times, Judge.
Thank you, objection noted. So moved.
I honest to God do not remember any of this on here. Like, I don't remember talking, I don't remember, I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your practice to lay law enforcement?
Objection.
Excuse me, can I
I've
see
never
the
do a lot.
Quiet, please.
So Ms. Holmstone, is it the transcript that you're saying is on that?
Sustained.
I don't know.
Excuse me, I sustained the objection.
Okay, so going back to the relationship with your daughter and defendant.
Yes.
How long did that last?
3 years, I'm not quite sure how.
Okay. During the course of that relationship, did she have multiple photographs of him?
I'm pretty sure she did.
Videos?
I'm pretty sure she did.
After this incident, on October 26, 2018, at Frida's house, is it your testimony that your daughter went upstairs with Mr. Dennings?
She did. They did go upstairs.
They went upstairs. And do you know about what time you got to Broward County?
I probably got to Broward, maybe, I can't really remember the time, maybe, I don't know, but 1 o'clock, it was after lunch, because we went to right after. So it was lunchtime, it was 1 o'clock.
Do you remember going to lunch?
Yes.
Do you remember where you went to lunch?
I don't remember which restaurant.
Do you remember who you went with?
My daughter and AA.
And that's James Francois' wife?
Yes.
And do you remember, your testimony to the jury, that you remember the defendant, how he was dressed without blood on his clothing?
I don't remember exactly what he had on, but I just remember that there was no blood, because that would have freaked me out, so I know he didn't have any blood on him.
No blood on him. Is it your testimony to this jury in terms of that you went to Frito Bang or Frederick Gibbons' house?
Yes.
Is it your testimony to the jury that there were other individuals present at that house?
Yes.
Who was it?
I don't know.
Do you recognize any of the individuals?
No, I don't.
Okay. Your daughter, she was present?
Yes, she was.
And in terms of your appearance here today,
yes.
You don't want to be here.
You don't want to be here. You made on here.
I did.
Yes, you
so,
did.
and in terms of you were served with a subpoena
Never served me.
And so you were ordered by the court to show up.
You never served me originally. That was a lie.
And in terms of your job,
yes.
Did you quit your job?
I got fired because you put me in jail.
And prior to that,
yes.
Before you were put in jail, did you quit your job?
No.
Okay. So you never quit your job?
I had to leave because you told my lawyer to put a warrant out for me. Okay. So I had to leave my job.
Okay. So you left your job?
Yes.
Did the defendant ever offer to pay for you and your daughter?
No. I make my own money.
Have you ever made statements contrary to that?
I don't remember.
If I may approach her?
Your Honor, objection.
Just show counsel.
Sure.
Can we approach?
Sure. Are you done with that?
Okay. Ms. Holmes, were you ever told the defense, or the defendant rather, would take care of you and pay for your bills?
No.
Have you ever made a statement that is different than that?
Never say anything like that.
Thank you everybody that's watching
Any
the
other
stream. Make sure y'all share the stream, bro. It's a great stream.
Just read this. I don't remember that.
Okay.
Yes, yeah, you remember my bills.
So, Ms. Holmes, is it your statement testimony that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us for all lives? They didn't want us talking with prosecutors, but now they've all disappeared. You've never said that before.
I don't remember saying anything like that.
Objection, Your Honor. Move mistrial.
Thank you. Why don't you go sidewalk?
Ms. Holmes, did you ever say the defendant made you quit your job?
I never really say anything like that. I know what's never made me quit my job.
Objection.
If I may approach him? I'm going to show you this next few minutes. Okay. So, Ms. Holmes, I'm going to ask you again. Have you ever made a statement that the defendant made you quit your job, that they would take care of us until the trial was over?
I don't really say anything like that.
Okay. So you're denying making that statement?
I don't really say anything like that.
Oh.
Objection. Your Honor, can I just have a standing
Yes.
objection so we don't keep interrupting?
Thank you. Any statements we heard on the standing objection?
Whatever defense
That's
chooses to
fine. Go
proceed.
ahead.
Okay. So, Ms. Holmes, in terms of you made a statement to the effect of you were told to quit your job and the defense would take care of us.
Objection.
No.
Excuse me.
The defense? No.
Why don't you come
Didn't say
sidewalk?
anything like that.
And we have another motion.
Ladies and gentlemen, there was an objection made to the last question. I made a determination that was an inappropriate, improper question, and the way it was phrased was totally improper, and therefore I sustain the objection. I am instructing you that you are to disregard the question. All right? I'm going to ask counsel to rephrase the question. Go ahead.
So it's clear. Ms. Holmes, did the defendant ever make you a promise to quit your job and that they had us?
Objection. Asked and answered.
Thank you. Overruled. Proceed.
I don't remember saying anything like that.
Your testimony is that you've never said that.
Objection.
I don't remember.
Excuse me, counsel, she answered the question, all right? Let's move on.
So with regards to your statements with Portland Henry. Do you remember speaking and talking about your daughter with Portland Henry?
No, I don't. When was that? I don't remember.
Sure. When was that? Here, I'll give it to you again. This was February 5th of 2021. Do you still have it?
Oh, no, I don't remember that.
You don't remember that? Okay.
Yeah.
Did you talk to Portland Henry about your daughter's involvement in this case?
Not that I can recall.
Ms. Holmes, did your daughter tell you what happened in this case?
Objection. No.
What's the objection?
Calls for hearsay. It's immaterial.
Not what the statement said, but did you say something about the case? It's overruled.
No,
Not
she
what
never
was
told me
said.
about it.
Just,
She
did
never
you have
told
a
me about it.
excuse me. Not what was said. Was there a conversation?
Was there a conversation that your daughter told you what happened in this case?
What do you mean what happened?
Did your daughter
No,
ever
she never told me. She hasn't. I asked my daughter, did she know anything about this case? And she said no.
Have you ever made a statement different than that?
Not that I can recall. No, I don't remember saying anything like that.
May I approach her?
Yes, ma'am.
We object.
Why don't you show it to counsel first?
Can we approach?
Yes.
Sorry.
Ladies and gentlemen, take a short recess. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case from the presence. Serving no research. Just leave your notepads on your chairs. We're in recess. Approach the defendant, his counsel, the assistant state attorneys. The jury's not here. They're adjourned. We all ready to proceed?
Yes.
All right. See if they're here, please. See if they're ready.
Jury entering.
Ladies and gentlemen, thank you. Let the record reflect the presence of the defendant, his counsel, the assistant state attorneys. Ladies and gentlemen of the jury, our witness remains on the stand. Please be seated. And remind you, Ms. Holmes is still on the road. Counsel, please continue.
Let me let Ms. Holmes, I can ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about that.
No. Did she tell you what happened? Without, no, she did
Just
not.
so she didn't know.
Have you ever made a statement that is different than that?
Your Honor, we'd object to the lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed to your approach.
Showing you your messages from Instagram from February 5th of 2021.
Who was that Instagram? Is that the one Instagram stands with Portland?
Ma'am,
I don't
sorry.
remember. I don't remember that Instagram.
Look at it.
I already looked at it. You want to show it to me?
So is the...
I don't remember that. You showed it to me like 3 times already.
So you don't recall making
I don't
a
recall
statement
making that statement. No,
Excuse me, one at a time, please. Let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
So you don't recall saying...
Objection.
Sustained.
So, Ms. Holmes, in terms, you said that your daughter didn't tell you.
Objection. Asked and answered.
Sustained.
So did you ever make a statement that's different than that?
Objection. Asked and answered.
Sustained.
Into the statements that, with regards to October 26th of 2018. Is it your testimony to the jury that you remember coming to Fort Lauderdale?
Objection, asked and answered.
Sustained. Listen, I just want one of you making objections. Whoever's going to handle the
Yes, sir.
witness. All right?
I apologize.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection. Asked and answered.
Sustained.
Ms. Holmes, have you ever let me rephrase. Ms. Holmes, did your daughter ever threaten to cooperate with law enforcement?
Objection.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection. Asked and answered.
Different question.
Why don't you come sidewalk? I want to see the question, please.
Ms. Holmes, did you ever make any statements about what happened on October 26th of 2018?
Objection. Asked and answered.
I don't know what statement you're talking about. Rephrase your question to a specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you. I still come on sidewalk, please.
So, Ms. Holmes, I want to ask, were you present when your daughter spoke with law enforcement?
She was 17, I had been present.
Do you recall about when that happened?
If she was 17, that had to happen in 2018.
Okay. Without getting into what she said on that, do you remember where that statement was taken?
No, I don't.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Calls for a conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
Sustained.
When you arrived in Fort Lauderdale and saw Mr. Dennis, did you ask him what happened?
Objection.
What's
Asked
the
and
objection?
answered.
Overruled.
I'm sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
I have one question.
Yes, sir.
You came here and one of your first, let me get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, counsel, you direct your comments to.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I did.
Thank you.
Anything else to this witness?
Yes, sir. Ms. Holmes?
Yes.
You said you feel threatened by me.
Of course.
Okay. Did you fail to appear for numerous court appearances?
No, you never served me, lied.
Okay.
You lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay.
Material. Overruled.
And so that was a location you were at?
That's why I was traveling or something, yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify?
You served me a subpoena on November to be the next week, and I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in February of 2019.
You never served me. You served me to a location I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Excuse me. Anything about the courthouse tonight?
Excuse me, come sidebar.
So, Ms. Holmes, you even went so far as to hire an attorney to try not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state has run my life.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have
No,
you-
I'm telling you.
that's not-
I don't
that's
know
not-
what
Excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, Your Honor. So that my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you with the 4th District Court of Appeals?
He had to hire an attorney because you tried to get him this far.
And no, that's a false statement.
Objection.
Excuse me, counsel, you're not testifying.
I
all right?
agree on
You
that.
excuse me, you asked a question, all right? That's it, you asked the question.
And so, Ms. Holmes, with regards to that, you hired an attorney?
Yes.
And you then tried to get any sort of court order requiring you to be here in court thrown out?
No, what I did was I hired an attorney because you were saying you served me the subpoena that you never served.
And that was found to be valid?
You never served me a subpoena that was never, you never served me.
Oh.
I've never seen a subpoena from you from those addresses that you said you served. Those
So-
are not my addresses.
Your testimony is that you have never been served to appear in court?
Objection,
I've
asked
served,
and
I've never
answered.
Sustain. Excuse me, sustain.
And so, with regards to your feeling threatened on them, have I ever, any sort of physical violence against you?
No.
Okay. Do you have any written threats from me?
It's intimidating. You've intimidated me this whole time. As
And,
of now.
and in terms of your participation in this case?
Yes.
You understand that you were served a subpoena to appear here today?
You served a subpoena after you arrested me.
And
you served
you-
a subpoena at the jail when I was in Brown County.
And you understand you're here pursuant to that court order?
I'm here.
And that requires, under the law, to comply with court orders to, and that compel the attendance of witnesses.
I've been complying.
Okay. Nothing further, Your Honor.
Anything further?
No, sir.
Thank you. Is this witness excused?
Yes, Your Honor.
Thank you, ma'am. You may step down. You're excused. Want to come sidebar here, please?
Sure.
Ladies and gentlemen, just checking with counsel. That's all the evidence we have for today. So my thought is, remember the admonition. We'll see you back on Monday, though, 9 o'clock. Remember, do not discuss the case. Tuesday, that's right. Monday's a holiday. Thank you. So Tuesday at 9. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. Certainly no research. All right. Same admonition I give you every time we break. We're counting on you to follow it. All right, just leave your notepad on your chair. We'll see you back on Tuesday, 9 a.m. Thank you. What did that? I don't know. Let the record reflect the jury stepped down. Counsel remain along with the defendant and the assistant state attorney. Ms. Bradley, my clerk is advising me that I don't know if it was, I don't think there was any evidence that she had something that might have been marked as an exhibit.
It was not marked, Your Honor. It was just a copy of the transcript.
So you're okay with it?
Yes, Your Honor. I have plenty of copies.
All right. In any event, so jury's been excused. Counsel remain along with the defense. So you have a couple motions from this trial. You want to talk about those?
Yes, sir. As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do, it advanced a ruse, pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Demons has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that means.
This is your motion for mistrial, Mr. Addison?
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Well, it's second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text, couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since, so just to let the court know there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence, and there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or Mr. Demon's interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm going to defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss with Mr. Demons whether or not his feelings about motion for mistrial. I think it's appropriate that he be consulted as well. But I haven't reached any conclusion about it, and so I'm going to see exactly what was said. I thought I heard what was said, and I'll check with the court reporter, get a little piece of that transcript, and we'll go from there. And I'll take it under advisement. But you talk with your client about it. We'll see everybody back on Tuesday. All right,
Yes,
sir.
Have a good weekend, sir. Judge, since we're breaking early today, can we have a few minutes with our client? Right
Sure,
now?
I'd like you to take a few minutes with him. I'd like you to talk it over with him.
Yes, sir.
Can we have the cameras off while we talk about it?
I can't hear you.
The camera's off.
Oh, you want privacy, that's fine. The cameras can be excused. They can go out of the courtroom.
Thank you.
Guys, everybody can go out of the courtroom. All right?
Thank you so much.
Thank you.
Adjourn. This is like a private conference area.
Thank you.
There's nothing more powerful than you making your thing happen, really going for it, doing business on your terms, giving it your all, making a difference, and loving what you do. Every single day, feeling fearless, fulfilled, free. When there's nothing holding you back, what would your thing be?
Well, good afternoon and welcome to the Law and Crime Network. I'm Linda Kenny Bodden. Our trial coverage today takes us to Idaho, where the man accused of fatally stabbing four University of Idaho students last year is set to appear in court. Brian Kohberger is expected to be arraigned today on 4 counts of first-degree murder and 1 count of felony burglary for the brutal slayings of Kaylee Gonsalves, Madison Mogen, Xana Kernodle, and Ethan Chapin. Kohberger has been in police custody, as you know, since late December when he was arrested at his parents' home in Pennsylvania following a week-long search for the suspect. Kohberger is expected to enter his plea today as part of the proceedings. And of course, we will bring that to you on air and online as soon as we have it. And stay with us, because later in our show, we will have a live question and answer hosted by Anjanette Levy, who is in Moscow, Idaho, as our boots on the ground. But before we get to that, just last week, the 4 University of Idaho students were remembered for their strength and inspiration as they were awarded posthumous degrees. Let's take a listen.
The University of Idaho awards posthumous degrees to students who completed sufficient coursework prior to their untimely death. This is a moment for us to acknowledge the contributions they've made and celebrate their academic achievement with their families here today. This spring, we will award 5 posthumous certificates and degrees. During a private ceremony on Monday, we awarded a certificate in marketing to the family of Xana Alexia Kernodle. A certificate in recreation, sport, and tourism management will be delivered to the family of Ethan James Chapin in the coming weeks. Later today, in our afternoon commencement ceremony, we will award 2 posthumous bachelor's degrees. A bachelor's degree in general studies to the family of Kaylee Jade Gonsalves, and a Bachelor of Science degree in sociology and criminology to Lupita Colis Ruiz. Now, we will present a Bachelor of Science in Business degree to the family of Madison May Mogen.
Wow, I am sure the families of these victims had to be crying as they listened to what could have been and what they could have watched with their children going on stage to get certificates and degrees. But with me to discuss all this and what is going to happen in court, you know him well, Bob Mata, criminal defense attorney, host of the Defense Diaries podcast, and of course, Ron Zambrano, trial attorney. So Ron, let me start with you first. I have read a lot online, people saying, well, will Brian Kohberger plead guilty today, or is he going to plead innocent? Tell our viewers what happens at the first arraignment after a grand jury indictment with a defendant.
Typically, the defendant's in a very nervous position, but by now he's already got his plea already set up. So I know a lot of people think he's going to plead. Not a lot of people, but some people are debating. I think he's going to plead not guilty. A lot of this evidence is circumstantial, and I think he'll take a shot. Because, but you know, with all the phone evidence, all the phone calls with boyfriends, and where his phone was, I think he's got a long shot. But I think because it's mostly circumstantial, I think he'll take a shot and fight it and plead not guilty.
And of course, Bob Mata, let's talk about this. When he gets to plead not guilty, his attorney could actually enter it for him, or he can speak. Now, there is a famous case that we all know about, and some people have read about, where a defendant said, I'm 100% not guilty, I'm 100% innocent. Do you expect that Brian Kohberger is going to actually enter the plea himself? And will he make a statement, or will this be just a mundane arraignment, as we know in criminal law?
I think it as much in my mind as I think that the defendant is going to make the pronouncement himself. In my mind, he's doing exactly what you said, but in reality, I think that Ann Taylor will probably enter his pleas for him. And I'm going to go with 99.999% he's going not guilty on all counts.
Yeah,
There's no way he
I
pleaded
can
guilty
see
to
that you're a
any of these.
betting person here, leaving a little bit of doubt. So, Ronald, let me go back to you. This is actually a very serious occasion because they're going to have a number of things happening in court today. They'll be discussing the gag order. They'll be discussing discovery. And there have been some, shall we say, hiccups, says the defense, on behalf of the state giving them discovery. But that's also normal at this stage. Give us the posturing that goes on before an indictment and right after an indictment.
So a lot of what happens before the indictment is kind of you're trying to just fulfill your duty so that later on there's no arguments that something wasn't copacetic, that there's some type of due process issue. So and anything that doesn't go 100% cleanly, there's going to be some wrinkles, and everybody kind of understands that. After the indictment, things kind of get more formal, and you kind of have to have your ducks in a row and T's crossed. But by then, the defense attorneys and prosecution have kind of been communicating already, and they should have a report in order to avoid anything that can become a real issue later.
And Bob, before I play some tape that we have, I have one more question to you. This likely is a death penalty case. There was another death penalty counsel that was added last week. She may do some real estate, but she's also death penalty certified in the state of Idaho. What do you think is going through the prosecution at this point, and do you think they're going to mention that in the defense at this point, at this arraignment?
This arraignment, no. I mean, it's possible, though. I think that the prosecution is absolutely going to be seeking the death penalty in this matter. You know, in terms of the timing of them reinstituting the death by firing squad in Idaho, the timing seems, you have two major cases that were happening. You had Vallow, and well, actually three, Daybell, but Daybell and Vallow were originally supposed to be one trial. It got, you know, those got severed, but, you know, we've got three major cases, all death penalty eligible. And it was very, very recent, I think in the last 6 months, that Idaho brought back death by firing squad. And again, just so people understand, they have to be unable to obtain the cocktail for lethal injection or to go to firing squad. It's not the default. So, and I wanted to throw that in there because I think they're definitely going to go for the death penalty. And I think that this might be the first guy that I've ever heard of in my lifetime that is killed via firing squad.
Very, very interesting. Now, everyone wants to see Bryan Kohberger, although when I tweeted his picture in my social media, I was like, oh, I'm going to be watching that for a long time. But the poor victims, if he is guilty, they're the last person, or he is the last person they saw, so we owe it to them. But let's watch him before he's actually arrested, when he's in the car with his father, shall I say, escaping Idaho, going to Pennsylvania. Well, that's something that'll be decided in the future, but let's listen and let's watch.
Hello. How you doing? How y'all doing today? Good, good. Take a look at your driver's license real quick if I could. See, he's right up on that van, man. He was right up on the back end of that van. I pulled you over for tailgating. Is this your car? Okay, cool. Where are you headed?
Well, we're coming from WSU, and we're standing early.
What's WSU?
University, basically. That is SWAT team area.
So we're okay. I'm having a hard time hearing you because of the traffic. So you're coming from Washington State University, and you're going where?
We're going to be going to Pennsylvania.
Oh, okay.
Yeah. So we're slightly punchy because we're driving for hours.
Hours, days.
We're driving. Well, almost a day.
Okay. And what did you say about some SWAT team thing? Or
Yeah, there was a mass shooting here.
Where? Interesting.
Well, it's horrifying because it's always the universe. You know what I mean?
Mm-hmm. So y'all work at the university there? Or?
I actually do work there.
Oh. Okay. Okay. Yeah, I hadn't heard about that incident just yesterday, or?
This happened this evening. About an hour and a half ago, we're still wrapping it up. I'm not sure there's two shootings, but they did shoot somebody.
Let's see.
And then we don't know about that actually. They were there for a shooting.
Interesting. Wow. Okay. So do me a favor, don't follow too close, okay? All right.